This
believe,
conference will now be recorded.
I believe the recording is both audio and video.
Okay, everybody is so advised. The hearing will please come.
Scott, just one point in terms of, I can see who the others are dialed in on audio. I just wanted to call out that my lawyer's on as well, and he'll be supporting in my discussion. Michael Gillette. Michael, are you on? I can't seem to see who are the other attendees who are not on video on the screen.
I can't see them either. If they didn't sign in and put a name in and turn on their audio, Mr. Kendry, then none of us can see them. That's a problem for you and your attorney to figure out.
No, I saw him on the line 5 minutes back, but Michael, are you on?
Can you hear me?
Yeah.
I can barely hear anybody. I don't know what my difficulty is.
We can hear you very clearly.
Are you number 17, sir?
Pardon me?
On my screen, it says attendee 17. Is that you?
It should say Mike Gillette.
It doesn't.
Oh, wait, I have.
Mr. Hearing Examiner, it's Avril
see.
Beatty again.
Ms. Beatty.
On my screen, I have everybody's name other than caller 1 and caller 3 and caller 4. It's possible that it's whatever version of the GoToMeeting software is either pulling the information with people's names or not. So it could be an application, a software glitch, effectively.
Mike Gillette show up now. Mike is showing as muted. See if you can hear us, or can you talk?
I can essentially hear nothing. Maybe I should try calling in.
That would be fine, sir.
All right, well, I'll disconnect and call back, and I'll just call in on a phone.
Okay, Ms. Beatty, you can let him in due course. Okay, let's try again. The hearing will please come to order. Good morning, I'm John Galt, the Sammamish Hearing Examiner. It is now about 9:40 a.m. on September 9, 2020, and I welcome you to the 9:30 a.m. hearing today. Our hearing today is an appeal. It involves reasonable use exception application number RUE 2018-00594. The appellant is Rupesh Kendry. Mr. Kendry is on the screen with us, and he apparently is also going to be represented by legal counsel, Mr. I believe the name was Gillette, who is having problems getting into the system. The respondent is the City of Sammamish Community Development, and it is represented today by Hillary Graber, attorney at law. The applicant is Lingering Pine Investments, LLC. Attention, Jerry Walker. And Mr. Walker is with us, although his video is not presenting, at least on my screen at this time.
Hello?
Who's that? Is that Mr. Gillette?
This is Mike Gillette, yes.
Okay, I'm just doing the introductory comments, sir. You may listen while I talk,
Thank you.
okay?
Okay, thank
Hello?
you.
Who's that?
This is Jerry Walker. I can't seem to get my audio or video to work online, so I've called in.
Okay, thank you, Mr. Walker. I do want to emphasize to everybody that this is an appeal hearing. This is not an original jurisdiction hearing. In other words, the question before me is not whether or not a reasonable use exception should be granted to Lingering Pine Investments, but rather whether the city erred, however you want to pronounce the word, in its approval of the reasonable use exception. The issues before us are limited to those issues that were raised by Mr. Kendry in his appeal letter. And they were 5 in number. Number one was summarily dismissed by me some time ago for lack of jurisdiction. The remaining four issues are it's issue number 2, criterion compliance 1, waiver of setback to under 15 feet in critical area. Number 3, evidence of soil erosion near boundary line recently poses great risk. Number 4, incorrect assumption in criterion compliance that there is no other reasonable use. And number 5, incorrect assumption that development does, and it's an abbreviation DVT, but I think it's an abbreviation for development. Development does not pose unreasonable threat to safety. Those are the issues in the appeal, and they are the only issues that we will be discussing today. My introductory remarks today will be longer than normal because we are holding this hearing remotely due to restrictions associated with the ongoing COVID-19 pandemic. I apologize for the length of these remarks, but I believe it's necessary to preserve everybody's due process rights. Today's hearing is being conducted remotely using a software program called GoToMeeting. People may participate in this hearing by computer with audio video capabilities or by telephone. This hearing is being recorded by a system that's built into the GoToMeeting program. It is my belief that the system is recording not only our audio, but also our video. I'm the presiding officer, but Avril Beatty of the city staff is serving as the organizer of the meeting. That gives her sort of an overall control of whose mics are on and things like that. She's the mechanical ruler of the roost, as it were. I have asked her to keep everybody's microphone muted, except for one representative from each of the three parties, appellant, respondent, and applicant, so that they and I can more fluently interact with one another as the hearing goes along. When one of the parties calls somebody as a witness, we will get that person's microphone turned on. I'll swear them in, and then we can begin testimony. And for those of you who are represented by counsel, you can either have your witnesses respond in a Q&A fashion, or you can just turn them loose to testify on the issues that are before us. Each witness is a party of record and be a party of record even if they don't testify. We normally have a parties of record sheet available in the hearing room so that when you come in or go out, you can enter your name and contact information at that time. Well, obviously we can't do that this morning because we aren't meeting in the same room together. So what I'm going to ask is that at the close of the hearing, I will log off and then I would ask all of you who testified to stay on board, and Ms. Beatty will make sure that she has the contact information of each person who has actively participated in our hearing. Because of the restrictions with COVID-19, I know the city would greatly appreciate it if you chose to use email address rather than post office address for contact purposes. And I'll leave that to you and Ms. Beatty to discuss at the end of the hearing. There was, I was going to say there was an opportunity for people to submit evidence that's not commonly done in appeal hearings. There is a formal evidence pre-filing process, which I will get into here momentarily. But occasionally members of the public do submit evidence. And normally that is submitted at the hearing and it's available for people to look at. About 15 minutes ago now, the city clerk sent me an email containing an 8-page comment letter from one of the participants whose picture is on the screen today, Ms. Wichter. I have skimmed through part of it. I doubt that anybody else has seen it. And so I will be providing a mechanism at the end of the hearing for the rest of the participants to be able to see that letter and to submit responses to it. If I didn't do that, I think we would have a serious due process shortcoming. And if there is any other evidence that comes in during the hearing today that was not pre-filed, that will be included in the material to which responses may be provided. I'll explain that process at the end of the hearing. I don't see any sense in taking the time to do it right now. Our hearing sequence today is going to recognize the fact that the appellant bears the burden of proof. So the hearing is basically divided into 3 blocks, if you will. There is the direct testimony portion, the rebuttal portion, and then the closing statements. The direct testimony and the rebuttal portion will be heard in the order of appellant speaking first, respondent city second, applicant third, and at that point, there may be some members of the general public here who wish to speak. If so, I would recognize them at that time. When we get to closing statements, only the 3 principal parties have the right of a closing statement, and the order will be applicant first, city second, appellant third. And that recognizes the fact that the appellant does have the burden of proof. A reasonable use exception is classified by the city as a type 2 land use application. And type 2 applications are administrative with the right of appeal to the hearing examiner. And that's what we're here for this morning, is that appeal hearing. According to the code, I have 10 working days after the close of the hearing or the close of the hearing record in our case today, because I'll have to leave it open for responses, at least to the Wichter comment of today. The 10-day period will start at the close of the response period rather than at the close of the hearing today. My decision, once it's reached, will be a final decision for the city, subject to the right of reconsideration and appeal to Superior Court. I include a paragraph near the end of each decision that briefly explains the reconsideration process and another paragraph that explains appeal. So I will let you read them when the decision comes out. They're of no particular benefit to you today, so I'm not going to take the time to recite that information. Are there any questions regarding hearing procedures?
Yes, I have a question. Can you hear me?
And who's speaking?
Mike Gillette, the counsel for the Kendrys.
Okay, Mr. Gillette.
I know that cross-examination is not always common in these hearings, but I understand that the rules of procedure allow the possibility of cross-examination in contested situations like this. I would ask that on behalf of the Kendrys, I'd be able to cross-examine witnesses that may be offered by the city or the appellant. I don't expect that. Go ahead. I'm sorry.
I thought you were through.
I was only going to say that I don't believe my cross-examination of any witness would be particularly long.
I appreciate that. Cross-examination is a routine part of an appeal hearing before me. So each of the principal parties will have the opportunity to cross-examine any witness from one of the other parties. I have a fairly simple common sense rule regarding cross-examination. I don't think we'll have a problem with it today because I don't think there are multiple attorneys representing an individual party. My rule is simply that there can be only one person from a party cross-examining any given witness. I don't go in for what I call tag team cross-examination. But as I say, I don't think that's a problem today. But Mr. Gillette, you'll have a right of cross-examination, the city will, and Mr. Walker for Lingering Pine will. Some of you know that I typically do a site visit prior to conducting an open record hearing. I do not do site visits for appeal cases. There are lots of reasons why I don't. I'm not going to bore you with them. The fact is, I do not. I rely on the testimony and the evidence that's presented by the parties and their witnesses. I do not view the properties beforehand or afterwards, for that matter. And to the best of my knowledge, I don't think in the work that I've done for the city over the years that I've been the hearing examiner, I don't think I have even driven by this particular piece of property. So I don't think I even have that kind of foggy, ancient recollection of having driven down this street. In appeal cases, our rules of procedure require pre-filing of evidence by the principal parties. And the parties in this case have done that. There is a process for them to file and number their own materials, and they have done so. I also mark for entry into the record what we commonly refer to as administrative documents, things like instructional letters that I have sent, email correspondence among the principal parties setting hearing dates and things like that. In many cases, the parties do not even assign an exhibit number to their own appeal or to their own departmental decision, although the city did in this case. And some of those documents end up being administrative documents. On Thursday the 3rd, I sent an email to the principal parties reminding them that in the interlocutory order of July 21st, I listed administrative exhibits number 9001 through 9007.2. And I told them in the September 3rd email that there were 2 additional administrative exhibits to become part of the record. They are exhibit 9008, a copy of that interlocutory order of partial summary dismissal dated July the 21st, and exhibit 9009, emails during the period of August 4 through 6, discussing the procedure for continuing the originally scheduled hearing. This morning, as I have alluded to, the city clerk sent me an 8-page document from Mary Wichter entitled Public Comment for Walker RUE 2018-00594 Appeal Hearing for Hearing Examiner. That statement will be entered as Exhibit 9010. And this is the document that we will establish a process for receiving responses from the other parties to at the end of our hearing. At this time, I propose to enter into the record administrative exhibits 9001 through 9010. I trust there are no objections to the entry of those exhibits. Those exhibits are entered. The city pre-filed exhibits from 1 through 17. Exhibit 3, if I'm remembering correctly, has about 12 or 13 subparts. So there's a lot more than the 17 documents. The city submitted its pre-hearing brief, but did not affix an exhibit number to it. And so in that September 3rd email that I sent to the principal parties, I told them that I would assign exhibit 18 to the city's pre-hearing brief. Are there any objections to the entry of the city's exhibits 1 through 18? Hearing no objections, they are entered. Appellant Kendry pre-filed exhibits 1001 through 1005. Are there any objections to the entry of Mr. Kendry's exhibits 1001 through 1005? Hearing no objections, they are entered. Applicant LPI, and I'll use that acronym if it's okay with the parties. Applicant LPI did not pre-file any exhibits on its own. Okay. We can now get down to the real business at hand, and that's receiving the testimony from each of the parties. As I indicated, we will be starting with the appellant. Before you were able to log into us, Mr. Gillette, Mr. Kendry indicated he would be the lead spokesperson. Is that now different by your presence?
No, Your Honor, it's not different. My role will be with respect to the other parties' witnesses.
Okay. Mr. Kendry, do you wish to offer testimony?
Yes,
Okay, would you raise your right hand, please, sir? Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. For the record, please state your name and spell it.
Rupesh Kendry, RUPESH, last name KHENDRY.
Thank you, sir. Go ahead.
So, first of all, how should I address you?
Mr. Galt or Mr. Examiner, the worst thing you could do would be to call me by my first name.
All right, Mr. Galt. Now, do you want me to go by each of those evidences I've filed, or is there a particular order you want me to follow?
How you want to organize your testimony, sir, is entirely up to you.
All right.
I just want it to be on the subjects in your appeal that remain before us today, numbers 2 through 5.
Okay, got it. So just some opening comments before we start. My assessment here is that, this is a complex RUE in terms of this is the only one in the Sammamish area that has several elements of critical areas, all of them, erosion, landslide, critical area, aquifer area, etc. So assessment thus far is being treated very much like a normal RUE. If I look at the city responses, it's really, the responses for the criterion compliances is really cut and paste of any RUE that was in the past. I believe there are issues of concern here that need to be addressed and understood from the standpoint of safety, welfare of the residents and neighborhood, from the standpoint of the risk it impacts from critical areas, soil erosion, landslide, etc. And it seems that the geotech report is quite dated. It's 2.5 years old. In the Sammamish area, we've had several landslides and flooding in the December of last year and February of this year, which I believe do not account for the increased risk it presents to the area. Also, of the nuance here is that I'm hearing some static and background. Appreciate if someone could mute if they're not speaking. So the nuances that persist here are the access, which is by what I still believe an alleged easement. But anyway, that's not for discussion now. And that would present an even increased risk to my home, dangerously close to my home, as well as to my neighbor's home. And therefore, we do want to raise the concerns here. Firstly, if I look at the initial part about the waiver of minimum setback, um, as SMC 21A 50.260 calls out, this is a landslide hazard area, and there are some code descriptions in terms of landslide with a minimum buffer of 50 feet, which may be reduced to 15 feet based on the critical area study. However, seems this project is going even lower than that. It doesn't state how low, but it says that it is going to be even lower than 15 feet. Now, the peer review that was done identifies that the reduced setback has not been addressed in the geotech report. So that is a concern because the geotech report was done in April of 2018. And based on that, the information that was presented in that does not account for reduced setback. So that's one thing to consider in terms of the increased risk it portrays. And additionally, if you see the evidence I have filed, there is a geotech report that my neighbor organized for the extension of her own home, Dawn Lovely, who's also with us today. And that has called out for a minimum buffer from the top of the slope to be at 30 feet. Now, considering that their home extension is not in the critical area, is on a reasonably flat land, they were still asked to stay away from the top of the slope by 30 feet. Now, this unit development in question is on top of that critical area. And it seems to be one biased in terms of allowing a home to be created so close on top of the critical area and having reduced setback, while another geotech report calls for a setback of a minimum of 30 feet. Now we know that there's steep slopes and severe to very severe erosion that has been called out by the geotech report itself, and there's a huge slippage hazard. And therefore, that presents a huge concern in terms of development on that critical area itself, to us as neighbors, to the unit itself. And that is the primary piece of information I want to provide for this one.
Okay. Does that conclude your testimony, sir?
For this specific one, yes.
For which?
For the first one, which is waiver of minimum setback requirements. I have multiple other testimonies. If you'd like, I could go through all of them.
I do want you to go through all of them.
Okay.
You get one shot at direct testimony, so take it while you've got it.
All right, got it. So just give me one moment.
So that was issue number 2, correct?
Yeah. The next one I want to talk through is really about the no other reasonable use. And if you look at the description in terms of what's defined for reasonable use, I do want to call out the definitions that have been outlined in the handbook by Washington State. Unlike variances, the purpose of a reasonable use exception permit is not to allow general development within critical areas, but to allow only minimum reasonable use of property so as to avoid a constitutional taking. And there are certain scenarios been identified in terms of what qualifies for being judged as a minimum use. The criteria for reasonable use permits needs to be consistent with case law, and the use of the term reasonable and its definition. Generally, the concept of reasonable has been left to courts, but a reasonable use is often thought to be a modest single-family home. And if I think about it from that standpoint, the footprint that this is going to create is 1,876 square feet. I don't believe this is anything modest. In terms of other uses that can be prescribed within RUE, within R4. It could be a ranch, it could be a farm, it could be a studio, it could be storage facilities. Now, I understand that may not meet the needs of the developer, but having said that, a footprint of that size is very large and it poses increased risks. The applicant has provided examples of the neighborhood areas, which seems to state that's in line with that. But on research, we have found there are several homes that are on a much smaller footprint of 1,200, 1,300, 1,400 square feet in terms of AGLA, average gross living area as I see it. And all of those do not have any critical areas. So if we think about the neighborhood in the same diameter and geographic distance that has been provided by the applicant, I've looked at other areas in that, and there are homes available without any reasonable use exceptions or any critical areas. And therefore, I think this footprint is large. If it's needs to go by code in terms of what is the definition of a modest single family home, this could be 1,000 square feet in terms of the actual footprint. And that would, I think, at least qualify as a modest single family home. I don't believe 1876 square feet qualifies as a modest single family home. So that information is public in terms of the home's neighborhood assessment. And I can provide that subsequent to this call if need be. If there's an option to project that, I can show the slide on screen as well.
I believe there is a way to share your screen and show it. I'm not terribly familiar with the GoToMeeting system, so I could not lead you anything other than astray if I tried to suggest how to do it.
So if someone makes me the presenter, I don't know if Lita, if you're able to do that, then I can share my screen. I've got the option, but I'm not a presenter in this meeting.
This is a real baby. Let me see how I can figure this out.
While you're doing that, Ms. Beatty, if he shares his screen and shows us an image, can that image be captured by you folks at the city so that you can make it, an item? Or is it to us only as long as it's on the screen and then it disappears?
It will be part of the recording of this hearing,
Okay.
but it would not be its own separate exhibit or document. So if it's something that hasn't been submitted to you, Mr. Hearing Examiner, or to the city, then we would not have it as an exhibit as part of the record.
Let's see what it looks like, what it is, because the rules of procedure do, in appeal cases, impose some limitations on the principal party submitting materials after the pre-filing process. So, Mr. Kendry, tell us, if you would please, sir, what are we looking at? Who prepared this? What is it?
So are you able to see the screen, everyone?
I am.
Yes.
Okay. So this was done by me. Some of this was obviously based on the city filing in terms of their neighborhood comparables. This is a geomap of the location area. What you see in red is the location of the proposed development. What you see in green is the examples that have been provided, I believe, by the applicant in terms of the sizing of neighborhood areas. So this was their example of information in terms of this being comparable to the neighborhood. Now, if you see the average gross living area here are in the 2000s, that the examples were provided by the applicant. But when I did my research here, I was able to locate similar examples in the same vicinity and neighborhood that the applicant has provided with a much smaller footprint. Now, the ones in yellow are the ones I have located from the public available information in terms of city records from the King County Parcel Viewer. And if you look at these are developments that have happened over the years and with similar or larger lots, but the footprint is much smaller. So I believe it's incorrect to state that this is the minimum footprint in terms of the neighboring homes. These homes are much smaller and they do not have any encumbrances from a critical area standpoint. And these still fit in the profile of the neighborhood. So from that standpoint, we believe that the definition of modest home is not accurate here. Um, and I just go back to the reference in terms of the code outlined in
Can you stop for a minute, please? Go
yeah,
back to your previous slide.
yeah.
Okay. Can you email a copy of that to Ms. Beatty after the hearing's over? I'm not going to ask you to do it while we're going on here, unless if you're technically capable to do that, be my guest, but I'm not going to try to insist that you do it. But can you email this to her?
I will do that.
Okay. I believe that this is an allowable document. It provides the numbers in support of the testimony that you've given us verbally this morning. This slide will be entered as Exhibit 1006. 1006, Appellant's Exhibit 1006. Okay, and Ms. Beatty, when you get it, you could either email it to me or tag it onto the list of exhibits that are out in the ether.
Absolutely, Mr. Hearing Examiner.
Okay, thank you. You may continue, Mr. Kendry.
Okay. The next piece I want to touch upon is the part about evidence of soil erosion. Now, as I called out that there have been several landslides and flooding in December of last year, as well as February of this year, and this is public record. Um, and I have attached as part of my evidence the erosion I have witnessed in my home, very close to the boundary line of the proposed lot. Uh, and this shows that there is evidence in impact from the flooding and landslides that have happened. As you,
May I interrupt, ask a question? Is that
yeah,
evidence, the three photographs that you submitted? Is that what you're talking about?
yes, that is. So the specific one,
Hang on a minute.
yeah,
They did not arrive to me attached to your appeal. And I originally was going to ask during the hearing what happened to them. I believe that
which
they
one?
are attached as part of Exhibit 13. And Mr. Kendry, if you can look, are you able to look at the exhibits online on your screen?
No, I don't see anything.
Exhibit 13?
Can someone share that? I don't know which one is Exhibit 13.
I'm taking them, I've got two computers here. I've got my desktop and I've got the laptop. And on my desktop, I've opened the Dropbox file that the city provides the exhibits in.
Oh, this is the city's exhibit file.
Yes, I'm sorry, I didn't make that clear. The city's exhibit list, the Dropbox list.
Okay, in Exhibit 13 on the city's Dropbox list, I see Beatty and Johnson emails.
Yes, and if you'll scroll through to page 3,
Yeah,
PDF page 3, it's a
yeah,
picture? Okay.
yeah, that's it.
Can you tell me, this is a question I was going to ask, and this is a good time to ask it. Where is that picture? Where was it taken?
Where was it taken, you said?
Yes, where is it? Where in the
Yeah.
world?
Yeah, so this is in the eastern end of my property, very close. The first picture, if I look at page number, I don't think there are any page numbers here, but the first picture um, is at the eastern of my property, which is very close to the property line, which would be the northwestern corner of the development area.
Northwest corner of your lot?
No, eastern corner of my lot, and it would be very close to the boundary line, adjacent to the northwest corner of the development site.
Now, is it on your lot or is it on
It's on my lot.
OPI's lot? This is on your lot.
This is on my lot.
If we go to the second picture,
Yeah.
and on my system, I have not been able to rotate this picture. It looks to me, I'm seeing it horizontally. Is that how you're seeing it? With a
Yeah,
fence?
that's how it's meant to be. So there's a picture is taken from a slight height. If you see in the
But the
background,
fence, is that a fence that's on the right edge of that picture?
that is, yeah.
And are those what appear to be 4x4 posts actually vertical in the ground? Because on my, they're horizontal.
Yeah, so
The
sorry.
picture's 90 degrees off, is that right?
No, this is how the picture is. The way it's taken, think of the elevation. I've taken from elevator point. This is my deck looking down into my backyard. But the slope coming down is from the fence. So this is a huge slope. The reason we have a fence is that it's very risky for our young children because behind the fence is really the lot in question. And therefore, there's a huge slope coming down, and the point you're looking at is really the lower part of that slope where there's evidence of erosion.
So I'm still confused on the directions. I'm having a hard time accepting that that picture is oriented correctly. Because
So if you notice, yeah,
the
go
fence
ahead.
posts on my picture are essentially, they're going left to right in the picture. Don't fence posts usually go up and down?
That's because the slope is dramatic. So you're seeing this looking up, if you can imagine. The point where the erosion is looks up to the fence. And then in the background, you see is sort of the neighbor's home right there. So if you orient yourself towards that, it's a slope going right to down the left.
Now
But you're right.
I'm really confused now. I thought a
If the,
minute or two ago, you told me that the development site is on the other side of that fence. Now I think you're telling me your neighbor's house is on the other side of that fence.
so
I'm
the, yeah, maybe I don't know if there's a better way to look at it on Google Maps. This is the fence. This is the fence that cuts through, doesn't cut through completely through my property. So my property extends beyond the fence as well on this side. Now, what you're looking at is partly is actually my lot, but
okay.
beyond that, the top corner of it is the lot in question. So in an ideal world, I could, if I took this from the bottom, where you see the concrete step, it's looking up from there.
Are we looking uphill?
Right now, we're looking left to right. The concrete point is the bottom of the hill. So if you stand there and look up towards the fence, that's where you're looking uphill.
So the step is on, this is all your property,
Yeah.
okay? Up to the fence, is the fence the property line?
No. So the fence cuts across. We have only demarcated the fence from the steep slope. So my home is beyond this fence as well. I have a small gate from the extreme right side that comes down to my backyard, which is beyond the fence as well.
Well, now, if your backyard is beyond the fence and the development site is beyond the fence, and the piece of concrete on the left of the picture you said is the bottom step from your deck, how can your deck be off the left edge of the picture while your house is behind the fence to the right? You see why I'm confused?
I don't know if there's a better way. Should I go onto Google Maps and show you maybe? I
Uh,
could take a minute to do that and project that on
And I'm
screen.
having a hard time, I guess I'm looking uphill, but I thought the land sloped downhill from your lot.
If you stand on the concrete step on the left corner of the picture and you face the fence, then you're looking uphill. So all of this is slope going all the way from the fence down to the concrete step. There's a picture taken from my deck, so it's at an elevated position, and I'm looking down behind my deck, which is still my land. It is, and beyond this, on the northern part of the picture, is the lot in question.
Which
There
is
is no
which
delineating my lot from that lot in this side.
which is the northern part of the picture?
The top, if you're looking up, Exhibit 13, where it's written, so I'm talking about from a directional standpoint.
Okay. And let me just make sure we're both looking at this the same way. The long dimension of the picture is running left to right on the screen. Is that right?
Yes.
That's how mine is too. Okay.
Mhm.
I'm sorry to seem so dense about this. I'm not usually this dense. I have a master's in geography. I've worked professionally as a photographer. I was an imagery interpretation officer in the Army for 3 years. I can read maps upside down and backwards usually. This one,
It's
I'm
not your
still
fault.
going around in circles trying to understand this picture.
I tried what's the best way to put it in a picture. It isn't easy to capture the slope as well as the intent of the erosion. I could take it to live Google Maps to present that, or I could even subsequently send more pictures um, if needed.
Well, a concrete step that in the lower left corner, is that an 8 by 16 paver, piece of paver? 8 inch by,
Uh, yeah, it's a standard concrete block, I would imagine.
okay.
So the erosion you'll notice is actually also has a depth to it. So while the spot looks like it's a piece of that, there's an erosion from where you see the light green grass going deeper into the dark black area.
And about how deep would you say it is?
Um, I would say it's about uh, 3 to 4 inches.
3 to 4 inches, okay. Okay, and the erosion is going from the bottom of the picture to the top of the picture, or from the top of the picture towards the bottom of the picture? Or some other,
It's generally going from the top right to the bottom left,
okay.
but it's going with the direction of the slope. So the fence side is the higher side, and there's a steep slope, I would say 20 to 30, 40 feet on this side, which is where the erosion bottom part you'll see on the bottom left of the screen.
So the LPI property is higher than your property?
Yes. Well, the LPI property is based on the southwest corner of that lot in question, and the property would potentially be on the same I would say height in terms of baseline of where their lot is the highest at. and everything else slopes downwards from there.
I see. So the corner's higher.
Corners higher, and that's the critical area location which the lot is built on. There's only a piece of corner which is, I would say, if not flat, at least reasonable, a very small lot, and it's steep slopes all around it. This is to the north side where the erosion picture is, which is steep, and
Okay.
then to the east side, which is very steep, and then the neighbor home on the south side.
Okay, now let's move on to the third picture, the one where it looks like you were standing right next to the fence and shooting pretty much straight down.
Yeah,
Is that your fence?
it is.
Okay, and is this, you said that the fence doesn't represent your property line. So this is on your property, even though it's what I would call outside the fence?
No, so I think might be good to explain that our fence doesn't cut across exactly the property line. The fence was created where there is slope. So the southern part of the fence is exactly the property line. And then as it moves further north, we have carved it to the slope area. So this one is exactly at the property line.
Okay. And we're standing outside the fence?
We're standing in my yard at the property line where the fence is at the eastern end of my property.
Sorry, I didn't catch that. Which end of your property?
At the eastern end
East
of my
end.
property.
Thank you. And am I seeing a drop in the soil near the bottom of the fence, sort of in the center of the picture? Is that what I'm looking at?
Yes. So this is an example of the.
How deep is that?
I would say this is about 3 inches, but it's very loose soil, and even just any impact of stepping on it, etc., creates some shift.
Okay, thank you. I appreciate you helping me understand those pictures better. You can go back to your comments on item number 3 about the erosion.
Okay. So that's what I was calling out. These are examples of erosion we're witnessing, which is very close to the shared boundary line. And we believe this is because the incessant rainfall, flooding, and landslides we've witnessed in the area. So I believe that the risk has really escalated since earlier this year. And considering that there, this is on that critical area, typically on the top of that slope, which there are buffers that need to maintain a minimum width around it. This presents an increased risk in terms of the soil erosion, landslide hazards, and since the geotech report was created over 2 years and 4 months ago, I don't believe that has accurately captured the current state of deterioration that may have transpired. And also that the peer review does call out that the setbacks have not been addressed in the geotech report. So I'm concerned that these are risks that have not been looked at, reviewed, analyzed by the city, and sufficient measures accounted for.
Thank you. Do you want to speak to any of the other issues? Actually,
Yeah.
there's one left.
Yeah, so we talked about the lesser impact piece. The other element that I want to talk to is the element of unreasonable threat to safety. I'm hearing a lot of feedback. Can you hear me okay?
I can hear you fine. I'm not hearing feedback, but I'm hearing some kind of background noise from some attendee somewhere. But I'm hearing you just fine.
Okay. So one other element I want to call out is that the um, setbacks that were mandated previously, and if you look at the information the city has provided, uh, setbacks were changed due to code change in May of this year. Now, while this application was considered complete in 2018, there have been changes to setback from the front, side, and rear. Um, and based on that, we have seen that the applicant has actually increased the footprint, which was previously, I'm going to say, close to 1,400 in terms of home and roof area of 1,576. Now suddenly became 1684 in terms of home port square footage and a roof area of 1876. What this has led to is obviously increased footprint, meaning increased pollution generating impervious surfaces, increased impervious footprint, and therefore I don't believe that the geotech report assesses this or the peer review assesses this. They call it out in terms of the increased footprint. So we already had a risk in terms of the footprint, which was previously 1576 square feet. And now the footprint has increased to 1876 footprint. And this was done in May of this year, soon after which we believe that the application was given the approval. So my understanding is that any due diligence that was done on based on the older reports in terms of geotech report and the technical information report that was provided, and do not account for a larger footprint that was approved. So that's another concern I want to call out. In addition to that, there is the key issue, I think, which has not been addressed at all, which is about the uh, threat to safety. Now, the access to this home is via an easement, which I still call, as I mentioned, alleged easement, which is a driveway. Now, if the driveway were implemented the way it has been outlined by a 20 feet driveway, you will see from my previdence filing that that gets dangerously close to my home, which is under 4 feet distance from my home structure itself. And that creates a huge risk to my family, my young children, because that is really our yard. It's too close to the building. And if we have heavy equipment moving in and out, there's a risk of fire, there's risk of accidents. And I don't believe that has been reviewed in any form by the geotech report or by the technical information report. In addition to that, if you look at the typical equipment sizing that needs to come up for plowing or development of land, these are each, minimum or average width of 14 feet. Now, if you have a 14 feet plower going into the driveway, it gets pretty close to where my home is and structure is. And as you know, this is meant to be a non-exclusive easement, so there is no, opportunity to carve this off separately to make it less risky. In addition to that, the utilities are currently on a bank on this easement area. Now, if these utilities would go in to support this lot in question too, there needs to be a separation of utilities as well. And finally, the other thing that the um, peer review has called out is the is the part about dispersion. And what I wanted to sort of talk about there is that the key issue is that there's creation of a driveway which would lead to a storm water runoff. Now, this calls for a 10-foot vegetation to be created along the driveway area to capture runoffs from stormwater. Now, that is a fundamental concern because there isn't any area available to create a 10-foot vegetated path running alongside the driveway to the north end of the easement, because the maximum width that you see from my pictures is 23.5 feet at best. So this has been also been called out by the peer review. I don't believe that is either been reviewed, assessed, or the fact that even the easement access and how utilities would be separated, how a vegetation path would be created for capturing the dispersion from the sheet flow is even fundamentally possible.
That concludes your testimony.
Let me take a look.
You covered all 4 of the issues.
Yeah, I'm just seeing if there are any points I have missed out. Yes, we can move forward.
Thank you, Mr. Kendry. Ms. Graber, does the city wish to cross-examine Mr. Kendry?
Yes, thank you.
The city does. Please proceed.
Good morning, Mr. Kendry. Can you describe any background training or education that you have regarding geotechnical expertise?
I have none.
Do you have any regarding soils or erosion or slope stability?
Other than a regular citizen, none.
Do you have any idea about how construction vehicles impact soil or erosion?
In what way?
Any expertise regarding that area?
Nope.
Have you hired a consultant or a geotechnical expert of your own?
I did try for it. I wanted to get expert opinion, but as you know, it isn't easy to get geotech lined up. So I've not been successful in doing that thus far.
Okay. Have you actually accessed the subject property to inspect it?
Yes.
And when was that?
I haven't crossed over, but I can see the subject property very close because it's next to my boundary line.
Okay, so you haven't actually entered the property.
No, I've not.
Okay, and who have you observed the property with? Have you brought anyone with expertise to observe the property with you?
Yes, I've had my contacts who are structural engineers that develop property. It's their feedback based on what they observed.
And are they going to testify today?
No.
Okay. So I want to talk briefly about the list of homes. I'm jumping ahead to neighborhood character. Are you, you said that none of the homes that you identified had a critical area overlay, is that correct?
None of the homes identified have the critical area overlay like this.
Mr. Galt, what are we calling that exhibit that he put up on the screen earlier?
It's exhibit 1006.
1006, okay.
Yeah,
Apologies.
the only way to get it back up for us would be to ask Mr. Kendry to do a screen share again. If you want.
I know, which is a little frustrating, but so to be clear, I'm sorry, Mr. Kendry, if I asked this question, I didn't hear your answer. So are you aware of whether or not any of the properties you identified in exhibit 1006 have critical area overlays?
not to the extent that this property does. This is the only property in the neighborhood that has all of these critical areas of slope, landslide, and critical area aquifer.
Okay, so I'm going to try and screen share as well if I can, Miss Beatty. I'm just waiting for the permission to do so. And I'm going to put up on the screen well, my background I'm going to put up on the screen. I'm going to put up on the screen somehow. Am I screen sharing at this point?
You are two nice looking little boys.
Two little dudes. Okay, I need to find a way to share my other screen, or maybe I'll just move that into the, here we go. So I am putting up what I'm now calling Cities Exhibit C19. And I'm going to try and minimize it because I understand that you can't see the whole thing at once. You shrink it down a little bit. And this is new in response to the exhibit Mr. Kendry put up. For some reason, I can't get the whole thing to go at once. Hold on. Okay. So, Mr. Kendry, are you familiar with the Sammamish property tool?
Yeah.
Okay, so the orange is the landslide hazard zone in the neighborhood, and the yellow and tan color is the erosion hazard area. So K is your house, W is the subject property. So are you aware that some of the properties that you identified are in fact in critical areas?
Are you asking me that?
Yes.
Well, if you overlay the map I presented, it's in the neighborhood of our home. So if you can identify, where the said property is, these homes are within that vicinity itself.
And I don't know how to stop screen sharing. I don't. Avril, can you just take permission away from me? Does that work?
Bear with me, I'm trying to.
Stop screen share. Just hover your mouse over, you'll see a screen in the bottom.
Okay, so I'm going to make Mr. Kendry the presenter again. Yes. Hillary? Ms. Graber?
Yeah.
Okay.
Okay, we should be back.
Okay, Mr. Kendry, you can now share that image again.
Okay.
Going to be what, exhibit 1006?
1006.
1006, okay. While he's bringing that up, Ms. Graber, did you want exhibit 19 to be entered?
I would like to be entered as exhibit 19, yes.
Any objection? Exhibit 19 is entered.
So much easier to do this in person with paper.
I don't know where we're getting that background discussion there. Other than myself, Ms. Graber, Mr. Kendry, Walker's mic is on. Attendee 21 and 20 just turned theirs off. That seems to have ended it. I don't know which one of you did it, but that's very much appreciated. Thank you. Now, what, we're waiting for Mr. Kendry to get 1006 back on screen share. Is that what we're waiting for?
That would be great.
Let me know if you can see it.
We're still not getting screen share yet.
I have it showing on screen share. Is nobody else seeing it?
I'm not.
Dawn, I see Dawn gave a thumbs up. Hillary, I
Rick-
did grab a screenshot and I
no.
emailed it to you.
Oh, I see that.
Should I go back to
Sasha,
Hillary being the presenter?
Yeah, let's try that again. I'll put it up on my screen.
Okay.
ND7 is the new presenter. There it is. Thank you, whoever.
Okay. Yeah, that's Ms. Beatty working through me. Okay, so Mr. Kendry, do you recognize now that some of your examples are in fact in the critical areas that you mentioned previously?
Yeah.
Yeah, okay. So, and I wanted to ask you about the data that you collected on this table. Do you have the actual numbers for impervious surfaces or home sizes on this table?
These are the home sizes on the right. So each of these are the lot addresses, and each of these is AGLA, which is what it was called out by the city's information as well.
Okay, and do you happen to know how much impervious surface is on those properties?
No, I didn't do that assessment. I just did it based on the table that was provided by the city, which basically called out the AGLAs, and I did the AGLA comparison to sort of provide the feedback around what is considered minimum use based on the justification that was there in that table.
But
Okay.
may I interject a question?
Yep.
Mr. Kennedy, what does AGLA stand for, please?
I believe it's average gross living area. That's how the King County Parcel Viewer
Average gross what?
living area.
A living area. Okay, thank you.
So my question is, is it your understanding that this accounts for, let's say, a garage or a concrete patio or anything like that?
It's the same comparison. I mean, the numbers are what was provided within your table, AGLAs. If you see the table that was provided, it's the same comparison basis I've used.
Okay. So I will stop sharing. Hopefully that worked. Did we all go back?
We're back.
Okay. Bear with me for one moment. My screens are all shuffled funny. So I did want to talk about what you just raised, Mr. Kendry, the city's exhibit. Where is the neighborhood? The city's exhibit 3.10, the neighborhood land analysis table. So are you saying that you took the properties from the city's exhibit 310, the land analysis table that the city provided?
Yeah.
And is it your understanding that the table that or do you understand how the table that the city created was made? Did the city create this? Did the appellant create, or did the applicant create this? Do you know where it came from?
I don't know. It was required in the evidence.
Okay, and so the table that you, or the map that you provided previously had 3 green triangles. In the city's exhibit 310, there are 17 different properties. So why did you choose those 3 green triangles in your exhibit?
Well, I chose those because I wanted to make sure it's in the vicinity of what the city had chosen. So there are several other areas that fall outside the scope, but if you look at the comparison within it, I chose the ones that are closer, and therefore I could compare with the similar ones in that area.
But you didn't take into account, let's say, critical areas or anything like that, correct?
No, I didn't take into account critical areas.
Okay, and the city's Exhibit 310, on average, the average AGLA is much larger than 2,000 square feet. Would you agree?
Yes.
Okay. Moving on. We spent some time talking about the erosion on your property. Have you done anything to fix the erosion on your property?
I've scheduled appointments with geotechs to come in and review.
So you haven't
That-
had a geotech review the erosion on your property yet?
Say that again?
So you have not yet had an expert come out and view what you allege to be erosion on your property?
Not an expert geotech. People who are involved in the building business, their assessment was there is land shift in erosion.
I'm going to stop you right there. That's hearsay. And I'd ask just that you answer the question posed before you. You have not had a geotech come out and review the erosion on your property, correct?
Not a geotech. You asked me if there was expert opinion. I still consider structural engineers to be expert opinion, so that was my response, but not a geotech yet.
Okay. And has that erosion on your property worsened in the last 2 years?
It has. It wasn't visible at all. None of this was available prior to the flooding area. We started noticing this earlier this year, and then we saw other spots come up. None of this was there last year.
Okay. And you haven't fixed it? You haven't done anything even just by yourself to resolve this problem?
No, I mean, I'm a layman, so I thought this was general stuff happening in the sand. But then I got some structural people to come in and take a look at my deck extension. They were the ones that pointed this out.
Okay. Have you ever received an opinion from any of your structural engineering friends that perhaps work that you've done on your property has caused or contributed to that erosion?
I've not done any work that would lead to that.
Okay.
We were just doing it for extensions.
I don't have any further questions.
I'm sorry, what did you say?
I don't have any further questions.
Oh, thank you. Mr. Walker, do you have any cross-examination of this witness? Is Mr. Walker still with us? He is, and it's, according to my screen, his mic is turned on. Mr. Walker, can you hear me? I guess not. Well, there's not much I can do if I can't contact the party in this situation. We'll just have to move on. Mr. Kendry, do you wish to call any witnesses?
Can I interrupt briefly? We have a paid expert witness here today, and I was hoping to take him out of order. So depending on how much longer Mr. Kendry has for his direct, I would ask that we bump our geotechnical expert ahead because the city's paying him hourly, I believe, to be here today.
If Mr. Kendry doesn't have any other witnesses that he was going to call, you folks would be next anyway.
Yeah.
Okay, so
Do you have any witnesses to call? It's a simple question, yes or no?
I would like to call upon the city witness. I don't know who that is. I don't know if the planner is available.
The
Or
planner?
who would be responding on behalf of the city planning?
The planner, not the city's consultant.
Not yet. First, I'd like to call upon the city planner.
Well, since you want to start questioning city witnesses, I'm going to honor Ms. Graber's request, and we're going to take the city's paid consultant first, and you'll be
Okay.
able to cross-examine him. Then you can go to the city staffer who's just on regular duty today, one presumes. So who's the consultant?
I believe we have Mr. Jeff Whale, Jeffwale, in attendance.
There's such a person here. If you are, identify yourself.
Yes, this is Jeff Well.
And where are you? on the screen?
Robinson Noble.
If you could, Jeff, could you wave so we know who you are?
Oh, okay. I thought your name was Robinson Noble.
Oh no, sorry, company.
Okay, we got a huge echo on your testimony, but let's see if we can deal with it. Sir, would you raise your right hand? Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Tell us your name again, please, and how to spell it.
Jeff Whale. That's JEFFWALE.
And you're with the firm of Robinson Noble, which is why your name shows as Robinson Noble on the screen. Is that right?
Yes, sir. Yes, sir. Yes, sir.
I don't know why we're getting that echo. This is the first witness who's given us that problem. Ms. Graber, your witness.
So, sorry, Ms. Bates.
Whoops.
Okay,
Try it.
She keeps turning me on and off. That's not me. Sorry about that. If I go mute again, somebody holler. Good morning. Could you just very briefly tell us about your experience and expertise as a geotechnical engineer today?
Sure. I've been performing geotechnical analysis in the Northwest for about 15 years now. And I'm sorry the echo is bothering me also. I've done a lot of slope stability analysis and erosion control analysis for sites throughout the area.
What's your education or certificate training that would enable you to be an expert here today?
I'm a licensed professional engineer in civil engineering. My degree is in forestry engineering, and I do have a certificate in geoenvironmental engineering as well.
And how long have you been with Robinson Noble?
Probably right at 15 years.
And what the kind of peer review that you performed, is that something that you do frequently?
Not frequently. I would say every other year or so.
And you reviewed the geotechnical report written by the Riley Group in this case, is that correct?
It is, yes. It is, yes.
And you're familiar with the subject property that we've been talking about? It doesn't have an address, but you're familiar with the Lingering Pine subject property, correct?
Yes, ma'am. Yes, ma'am.
Okay. And your report is entered into the record as City's Exhibit 8, so I may refer to it as that. It was authored December 21st, 2018. Is that correct?
Yes, that is correct.
What kind of investigation, aside from reading the Riley Group's report, what kind of investigation or inspection did you do on your own to prepare your peer review?
A superficial walk of the property.
Wow, that is a really bad echo. Is that enough? Is that sufficient? Would you typically go out and take measurements of any kind or studies of any kind?
Yes, make measurements if there's anything that's requiring or that analysis. It's generally just a superficial walk.
So no need for that was required in this case, correct?
Correct.
And did you do any research as to the subject property other than the superficial walk? Did you review any other documents or anything like that?
Yes, I use the download a erosion report for the site. I do use the city or county GIS data. That's all I can think of right now.
Did you review the entire application submitted by the applicant as well as the Riley Group review?
I'm sorry, I didn't catch the beginning of that.
Oh no, do I have an echo too? Did you review the entire application prepared by the applicant in addition to the Riley Group's report?
Yes.
And did you speak to anyone in preparation for your peer review?
Did I speak to anybody?
Did you talk to the applicant or the city staff or anyone, or did you just dive right in?
Trying to remember. I don't recall
okay,
speaking to anybody at this moment.
I'm sorry. Okay. So I will just dive right in to the report. The report makes various recommendations. Can you just sort of summarize for us what your concerns about the property were and how you believe that they were addressed?
Mr. Boyle, do you have any idea why your system is echoing so badly, sir?
Yes, my speakers weren't working, so the only way I could listen to the meeting was to dial in also, actually.
You have to mute the speakers,
Yeah, can you mute
your computer.
your audio?
I'm actually going to turn the GoToMeeting off if that's okay.
You've got no echo right now.
This is perfect.
Okay.
Whatever
Don't-
you're doing,
don't
keep
change
doing
it.
that.
I'll
Don't
pick up
touch
the phone and lock the speaker in.
Okay, perfect. Yeah, the computer was probably picking up your speakerphone. Okay, I asked you to summarize and can you summarize the general problematic characteristics on this property? We'll start there. What makes this property unique?
The steep slopes on the site, certainly over the 40% requirements.
And is it typical for someone who owns a parcel like this to want to develop it? Do you see this a lot?
I do get calls on them occasionally.
And is it possible to put a single family residence on a property like this?
It is possible.
And did the Riley Group's report give you sufficient information to determine whether or not it's appropriate in this case?
I believe so. They met the steep slope requirements for the slope stability analysis.
And did you find any, were there any areas that you thought were not sufficiently addressed by the Riley Group that resulted in you making additional recommendations?
The stormwater discharge, I wasn't clear on in which direction that was going. And then they didn't put any fill material in this slope stability analysis. So I made a comment that if the structure is going to sit on fill, that it needs to be addressed. I believe that's all I recall.
And so was it your conclusion that subject to those two things being addressed, that it was appropriate to develop the property as proposed?
Yes, I took no exemptions to the report.
Can you say that again? I didn't hear the first part of your sentence.
I took no exceptions to the report in my analysis.
Okay, so to be clear, you believe that the proposed project application satisfies the minimum requirements for a reasonable use exception?
Yes, ma'am.
Okay, and you conveniently were listening to Mr. Kendry's testimony earlier today. Was there anything that he said that caused you to change your mind on your opinion?
Some of the photos I was looking at, I mean, I didn't see enough in the photo to make a determination, but they were interesting.
The photographs that were taken on Mr. Kendry's property?
Correct.
Okay, but they weren't clear enough for you to change your mind based on what you've reviewed so far?
Correct.
Okay. I think I have a few more questions. Did you think about the setbacks at issue in this matter?
Yes, the report, I'm sorry, I still have the echo on my phone here.
Oh, no, I'm sorry.
The report didn't call out a setback. Typically, I would call an effective setback, which is more relevant to the distance the footings exist to the slope. And maybe in the true definition of, or the city definition of a setback, maybe it's not feasible to have one at all.
So, I'm sorry. So did you, I'm pulling up the Riley Group report. In the Riley Group report, which is Exhibit 1, City's Exhibit 1, did that report analyze, do you recall, do you have that in front of you? I should ask first. Do you have the Riley Group report in front of you?
I do, yes.
Do you recall whether or not that report talked about setbacks?
I do not recall it talking or giving a setback.
Is that something that geotechnical experts typically do?
Yes, we're going to provide a setback. Now, often that is an effective setback instead of the traditional setback.
Okay, and did you review plans for this proposal, this proposed development?
I did see the plan set. To see who prepared it. Daniel G. Weller, sheet A1.
And was there anything in your analysis that would cause you to second guess the setbacks proposed in that?
The downslope side of the structure has a basement elevation at 431, and the grades beneath that area are in the 420 range.
Does that cause you concern, or does that cause you to reevaluate your opinion?
No, it just.
Okay.
No concern. I guess just how the structure is, or the base of structure is in relation to the slope.
Okay. Did you analyze the amount of impervious surface proposed in this development proposal?
No, I did not.
Is that something a geotechnical expert would typically do?
I guess it's where the water is going from the impervious surfaces.
Okay, so you did think about that. Maybe I asked the question wrong. You analyzed the drainage coming off of the impervious surfaces in this matter?
Correct, yes.
Okay.
And
you mentioned that there was one item sort of lacking from the Kendry group, sorry, not the Kendry group, the Riley group, and you noted that in your report as a correction that needed to be made?
Yes.
Okay, and other than that, Mr. Kendry said earlier that the sheet flow from the driveway was a concern and wasn't addressed, but did you consider the sheet flow and sort of the drainage of the entire parcel when you made this recommendation?
Oh, well, in relation to the sheet flow, would be just the driveway.
But you thought about that when you reviewed the Riley Group's report and made your recommendation?
Yes.
Okay. And you stand behind your report in Exhibit 8 today?
I do, yes.
Okay, I have no further questions.
Thank you. Mr. Kendry, do you wish to ask any questions of Mr. Whale?
Can you hear me? Yes, I do.
Okay, you may cross-examine him. Remember, you're asking questions now, you're not testifying.
Got it. Mr. Whale, thanks for joining us today. My first question, just to clarify, what was the date of your report?
Date of the report, December 21st, 2018.
Okay. And were you made available the site plans as well as part of the document you were reviewing?
The sheet A1 is what I have available.
Is that a site plan?
Yes,
Okay. Were you made available the information that then modified the site plan in May based on the reduced setbacks? This happened in May of 2019.
no, I was not.
Okay. So you also in your peer review have called out that the reduced setback has not been addressed in the geotech report. Is that correct?
Can you repeat the question again?
Your peer review report dated December 21st, 2018 states that the reduced setback has not been addressed in the geotech report.
Correct,
So
yes.
how were you able to analyze the reduced setback?
I have not, no.
You have not done that. Additionally, the site plan was changed, as I mentioned previously, from an area of 1576 footprint to 1876 footprint in May of 2019. So imagine that based on your analysis done in December 2018, you have not reviewed it from the increased footprint and risk associated with that.
That is correct.
Okay, thank you. The other question I want to call out is what you called out as a risk in terms of the dispersion challenge on the driveway. You mentioned that you had done a physical analysis of the site. Did you also do a physical analysis of the driveway?
I did walk that area, yes.
You did walk on my property where the driveway is?
Correct, yes.
Okay. So within the report, you mentioned that the report indicates 10 feet of flow path exist for sheet dispersion from the planned driveway accessing the site. And you state that our review of project plans does not indicate that this 10 feet of flow path exists between the driveway and the northern extent of the easement. Do you still stand by that?
Yes, from the plan sheet I have seen.
Okay. Was this concern addressed, responded by the city or the officials to you in terms of how they plan to address this fundamental issue without having the appropriate width available in the driveway?
I have not seen anything.
All right. Thank you. I just want to call out here about the fact, going back to my exhibit, was the width.
You asking him a question now?
No, I think I'm done with questions for you, sir.
Thank you. Thank you.
Mr. Galt, are you hearing me now, Mike Gillette?
Mr.
Can you hear
Gillette?
me? Yes, at the beginning of the cross-examination, I tried to speak. I'm not going to, because I was anticipating doing that cross-examination, but I wasn't able to be heard. And I wonder if I don't know why that was, but I called back now. I redialed and called back in, and I could be heard. I don't know if this is the same problem that Mr. Walker was having, but it's obviously we're dealing in a world where these things do happen, but it's a little frustrating for me, and I suspect for Mr. Walker.
And for me, do you want to, I will make a special exception because of the technology problem and the fact that you tried to get in to do the cross-examination and couldn't. If you have any additional questions, not to duplicate what your client has already asked, but if you have some additional ones, I'll certainly allow you to go ahead and do that.
Well, I don't, let me summarize what I understand my clients have asked about, because I was trying to listen at the same time trying to get back in. I believe he did ask questions regarding the stormwater discharge concern that Mr. Whale identified, and got elaboration on that concern, and whether or not that concern was adequately addressed by the city. Is that a fair statement of what that cross-examination entailed?
He did ask questions about that. He also asked questions about what he described as revised plans that showed an increased footprint and reduced setback.
Okay, well then I have only one area.
About that.
Okay, I have only one additional area I'd like to ask about, which is, Mr. Whale, did you, as part of your peer review, did you look at the potential safety impacts on the Kindry property and the Kindry family resulting from a driveway that is as close as 4 feet to their house?
I would say no. Just looking at the geotechnical aspects.
And would that be something particularly within your expertise if you had been asked to look at that?
No.
I have no further questions.
Thank you, Mr. Gillette. I might note here in passing that I'm not sure that I have seen, or if I've seen them, I'm not sure that I recognize two different site plan proposals in the exhibits. I only see one set of plans, and that's Exhibit 5. And there's another set in here, there's a couple different sets. Someplace along the line, I'm hoping that somebody on behalf of the city or on behalf of LPI will be able to point to these two different plan sets with the different building sizes and the different driveway runoff proposals that are being discussed here, because I'm not sure that I'm clear where those two sets of plans are. That's not a question, Mr. Whale, however. I was trying to find them while he was talking, and I thought I better mention it while I was remembering it. Okay. Mr. Walker, are you able to communicate with us? Your little gray square says that your mic is on, but we've tried this before and you have not been able to talk back to us. Are you with us now? It's apparently not. Is there anybody else representing LPI that is able to participate? I'm sorry for all this. I'm sorry it's happening. I'm not sorry because I didn't do it. I'm not the one causing the technical problems. And I don't think the city probably is either. I think it's the nature of this fun beast that we're dealing with.
Mr. Hearing Examiner, it's Avril Beatty. There was a caller who just dropped off. I'm wondering if it was Mr. Walker who's attempting to call back in. So an option would be to wait a minute or two to see if an additional caller comes back in with a more adequate audio connection.
I'm game. Here's a new attendee. Attendee 20.
Hello?
Are you Mr. Walker?
Yes, the problem is I've called in and then you guys muted me and then I couldn't get unmuted because I had no way to talk to you. So I've been listening the entire time, but you just have not been able to hear me.
Okay. Mr. Walker, do you wish to cross-examine Mr. Whale? I guess that's where we are. It's kind of hard keeping track of where we are.
Sure, just a couple of quick questions, Mr. Whale. If the setbacks had changed a minor amount, would that affect your analysis at all?
No, they seem to say that the site's stable with the structure in place.
Okay. And conversely, if the footprint had increased a few hundred feet, would that affect your analysis at all?
I would leave that up to the Riley group to perform that analysis.
Okay. I have no more questions.
Thank you, Mr. Walker. Okay. In the interest of expediting things, you may have noticed that I have not at any point gone back and asked if there's any redirect. I'm going to leave it to the parties if they feel it appropriate or necessary to get in a redirect, that you're going to have to jump in and ask for it. Otherwise, I'll just keep us moving along here. Now, technically, we are still in Mr. Kendry's testimony here. He was going to call Mr. Whale, and we let the city call him, and then he's crossed. You also said, Mr. Kendry, that you wanted to call the city's planner. And I'm presuming that that's Mr. Johnson, who's activated his picture on the screen for us. Do you still wish to ask him to testify?
Yes, I do.
Okay. Mr. Johnson, are you the city planner that he would be talking to?
Yes, Mr. Galt.
Okay. Would you raise your right hand, please? Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
No.
Thank you.
Can I interject before we get started and do a little scheduling? I don't know if there's a limitation on how long our hearing's going to go, but it's been almost 2 hours, and I was wondering if we should plan for a break or a lunch at some point, maybe right at noon, maybe before or after.
Well, let's see if we can get through Mr. Johnson before we face that reality.
Okay.
So I have never had one of these where we've had to stop and start all over again after a luncheon break. We've done a 10-minute recess, and I think it was a different jurisdiction, and they just kept the system going. And we all just blanked out our pictures so we could drink water or whatever we wanted to do.
Yeah, that's what I've been doing as well.
Yeah, and get up and leave the room without everybody seeing what's on your lower half of your body. Which in my case would be a pair of shorts that don't match the color of anything else I'm wearing. So, but if we're going to do a lunch, then I don't know, I'll let Ms. Beatty be thinking about this while we listen to Mr. Johnson's testimony.
Second point of interest. Second point of interest is I'd like to excuse Mr. Whale.
You certainly may on my part. Any objection to Whale?
Nope.
Objection. You're excused.
Thank you, Mr.
And
Whale.
sorry for the echo.
You can turn off the clock now.
That's all I have.
Okay.
Now, Ms. Graber, as Mr. Whale, do you want to ask the questions that you would ask your witness normally and then let Mr. Kendry cross him? Just like we did with Mr.
With regard to Mr. Johnson, I'll leave that up to you. It's frequently, he didn't identify him as a witness, so I wasn't prepared for this
Okay.
mentally.
We'll let Mr. Kendry ask him. We'll let.
Yeah, he can go ahead and I'll do my direct next.
Very good. Mr. Kendry, let's see, did we, Mr. Johnson, and all of that, did I ask you to state your name and spell it for the record?
You did not, Mr. Examiner.
I did not. Well, consider that I just did.
Okay.
Go ahead.
My name is Andrew Johnson, ANDREW, last name Johnson, JOHNSON.
Okay, thank you. Your witness, Mr. Kendry, or is it going to be, let's see now. Mr. Gillette, are you still with us?
I hope I am. Can you hear me?
You are. You indicated to me way back earlier in a little dialogue we had that you intended your role to be to cross-examine other people's witnesses. Grant, this is direct questioning, but is this somebody that you and Mr. Kendry intended you to do the questioning of, or was Mr. Kendry going to?
I'm going to reserve my role until the city calls Mr. Johnson as their witness, and I'll conduct the cross-examination.
Ms. Graber, did I not understand that you said you had not intended to call Mr. Johnson?
I identified him as a witness. Mr. Kendry did not. So I was not prepared for him to be, questioned first. I was expecting to do direct of him first, but I'm open to however we want to play this out.
I just would hate to have him called twice.
He'll be called twice for sure if we do it this way, because he's my witness. He's my star witness. He wrote the staff report, so he'll be talking for me.
Hey,
I think it makes more sense to let Ms. Graber put her witness on now and let Mr. Gillette cross-examine him, as opposed to having Mr. Kendry have him as a direct witness with Ms. Graber cross-examining him. I think we will all be better served if Ms. Graber treats him as her witness now, then Mr. Gillette, you can cross-examine him. How's that sound to you?
If that's acceptable to my client, that's acceptable to me.
Mr. Kendry?
Yeah, it's okay.
Okay. Ms. Graber, are you game for that now? It's 11:30, give or take. Do you think your testimony with him is going to be more than a half an hour?
I would bet it'll be right around there. Depends on how quickly he talks, but it'll be a half an hour or more.
Okay, then in order not to break up our dealing with him, let's deal with the lunch question. I will need a break, that's for sure, here in the next few minutes. I don't care whether I get a lunch break or whether we take like 15 minutes and then get back together again and just plow on. That doesn't bother me. And I recognize that ultimately I am the decision maker who gets to decide how we're going to do this. But when it comes to things like this, I at least like to sort of poll the audience and see what the sentiment is. Ms. Graber, what's the city's preference? Full lunch and break?
I think it makes the most sense if we want to do a longer break, maybe take a 20 or 30-minute break now instead of a typical lunch, just so we don't split the testimony in half. I think that's wise. And then Avril Beatty can mute all of our screens, and we can all shut our screens down so we're all silent and unseen, as opposed to having everyone log off and back on.
That works for me. Mr. Kendry, you good for a half an hour break?
Yep, works for me.
Okay. And do we have LPI?
Yes.
Good. You're still with us?
Yes, as long as you don't mute me, I'm still with you.
Does a half an hour break at this point make sense to you?
Sure, I'm happy to reconvene at noon and go from there.
Okay, it is 11:30. We will now stand at recess for 30 minutes, reconvening at noon. And Ms. Beatty, I don't know how you want to treat all of us, but if you can blank us out. Can we blank ourselves out?
I will mute all. Everybody can turn off their camera. I don't.
That's down at the bottom.
Can we just disconnect?
I can't pause the recording. So I'll just leave the recording on. They'll just be blank for half an hour. I'll mute all, and then when we come back at noon, I will unmute all so that everyone can have the ability to mute them and unmute themselves.
Okay, and then we may have to do some checking on Mr. Walker, because apparently whenever he's muted, he can't get back in. So we'll deal with.
I think, yeah. I'm hoping that unmuting all will make it work.
Okay, we are at recess until noontime. Thank you all very much.
Hello? Is my
Hello?
mic working?
Hi there. Yeah, I can hear you, Mary.
I just want to check my mic. I haven't done it with GoToMeeting, so I'm going to mute myself.
Yeah, the user
Always,
interface is different here.
always remember, you can say what you see, expert or not. You're doing good.
Thank you. Yeah, Mike, you're able to hear us?
Okay. Are we all here? Apparently. Mr. Gillette, are you?
I am here.
Excellent. Mr. Walker, are you?
Yes?
Excellent. Good. Okay, then I think we can reconvene. My computer says it's 12:02, so we are back in session for the afternoon portion of the hearing in RUE 2018-00594. We begin this afternoon with Ms. Graber examining her witness, Mr. Johnson. And then after his cross-examination, I will be returning to Mr. Kendry to see if he has additional witnesses to call. And if not, then we'll go back to the city again. They have additional witnesses. So, Ms. Graber, we swore in Mr. Johnson, so he's all yours.
Wonderful. Could you state your occupation for the record?
Yeah, it's associate planner at the city of Sammamish.
How long have you been in that role?
I have been a planner at the city of Sammamish for just under 2 years.
Can you tell me a little bit about your experience and education that led to this role?
Yeah, I pursued a BA in urban studies for community development and planning. And then I have subsequently had a planning role for 2.5 years.
And do you have any certificates or other sort of relevant education or training?
No.
Okay. Are you familiar with the Lingering Pines investment property that is the subject of this matter today? It's located at 446-211 Avenue Northeast Sammamish, approximately.
Yes.
Can you describe the property generally?
Yeah, it's just under a half an acre, zoned in the R4 zoning district, and it's located or mapped in the landslide hazard area, erosion hazard area, and critical aquifer recharge area, or CARA.
Is it fair to say that these critical areas encumber the whole property?
Yes.
Okay. How did you become familiar with this property?
I took over this specific application after a previous staff member had done the review, but the application came in on September 25th, 2018.
And what was the application for?
It was for an RUE, or a reasonable use exception for a single family residence.
Okay.
and
Uh,
infrastructure.
And just so I'm clear for the record, that application is contained in City's Exhibit 3.1 through 3.17, is that correct?
Yes.
Okay. What was the proposal at that time?
The proposal was to for a slightly smaller footprint of single-family residence, and was revised in May of last year to 2019 to for a little bit more than 300 square feet of impervious surface.
And is that revision contained in the City's Exhibit 5?
Yes.
Okay. Did you process the application?
The city did. The application was determined to be complete, and we did a public noticing for after the application was deemed complete, and we received 10 public comments.
Okay, what was your role at that time in terms of public comments? Did you collect, review, and address all those comments?
City staff did. I did not.
Okay. Have you reviewed how the city responded to those comments?
I have.
And are those responses by the city contained in the record here?
Yes.
Okay. And would you have done anything differently in terms of all the input the city received in terms of public comment, or do you stand behind what the city did in the response that it took to those public comments?
I stand behind what the city has done.
Okay. And so after the public comment was received, what happened next?
The review of the application and multiple reviews of the application were reviewed by city staff and sent to third-party review to determine whether the application was feasible.
And what was the conclusion?
From my understanding, from what the third party provided, it said that the application was feasible.
Okay. Did the city issue a notice of decision?
Yes, on May 15th, 2020, which approved the RUE.
Okay, and that's contained in the city's exhibit C12, correct?
Yes, correct.
And so at what point in this process did you actually come into play?
I came into the process in February of this year, 2020, and wrote the staff report and put the exhibits for the staff report together.
Okay. What is an RUE in Sammamish?
Yeah, RUE is a reasonable use exception, and it's shown in the SMC. If the city's environmentally critical areas regulations deny all reasonable use of the property.
So it's essentially an exemption to the city's critical areas requirements?
Correct.
And is that contained in Sammamish Municipal Code 21A 50070 subsection 2?
Yes.
Are you pretty familiar with that part of the code these days?
I'm getting more so.
Can you just tell us, I know that there's 4 requirements for analysis for the city to address when it's talking about an RUE. Can you just run us through those 4 requirements very quickly?
Sure. First is the application of this chapter would deny all reasonable use of the property. Secondly, there is no other reasonable use with less impact on the critical area. Third, the proposed development does not pose an unreasonable threat to the public health, safety or welfare on or off the development proposal site, and is consistent with the general purposes of this chapter and the public interest. And Fourth, any alterations permitted to the critical area or buffer shall be the minimum necessary to allow for reasonable use of the property. And any other authorized alteration of a critical area under this subsection shall be subject to conditions established by the department, including but not limited to mitigation under an approved mitigation plan.
And is an RUE something that happens once in a blue moon? Is it once every 10 years or is it more common than that?
It's becoming more common as people will like to develop vacant property on or within the city of Sammamish.
Okay. Does an RUE approve a specific design or plan set?
No.
Is that just one component of the application to prove that it's feasible?
Correct.
Okay. So, and just to circle back, I want to make sure that we have this in the record. The new plan that everyone's been talking about from 2019, that is in the city's exhibits, correct? That's Exhibit City 5.
Yes, it's in the staff report and as well as an exhibit in the testimony here today.
So when you authored the staff report, that was something that you took into consideration in your analysis?
Yes.
Okay. And so did you analyze the applicant's application under the Sammamish Municipal Code Chapter 21A 50070?
Sorry, say that again.
Did I say it wrong? Did you analyze the applicant's application under SMC 21A 50070?
Yes.
Okay. Can you tell me, and I'm going to go through this, and I appreciate that there's a lot to unpack here. So I just want to go through those 4 elements to get the testimony in the record. So if at any point you lose the thread, you let me know. Can you tell me what your analysis was under the first prong, which was whether or not the application, or sorry, whether or not the critical areas regulations would deny all reasonable use of the property?
Yeah, so the property is completely encumbered by the landslide hazard area, or LHA, and associated buffers, leaving basically no development space. A reduction in the buffer from 50 to 15 feet would still not allow any development of the property. The 21A 50 doesn't provide really any mechanism to allow for the construction of a single family residence with associated infrastructure. And we believe we provide strict adherence to code provisions relating to the landslide hazard area, which would deny all reasonable use of the property.
Okay. So in your opinion, was it appropriate for an RUE under that first prong?
Yes.
Can you think of any way adhering to the critical areas regulations that this property could have been developed?
No.
Okay. So going to the second prong, that there's no other reasonable use with less impact to the critical areas. What other reasonable uses could there have been in this area?
Well, single family residence and infrastructure are permitted and reasonable uses under for this particular property. And there is no reasonable use allowed in the R4 district with less impact than a single family residence, in our opinion.
So I heard the appellant earlier say that a studio or a ranch would have been allowed there. Is that, in your opinion, less of an impact on this residential neighborhood?
I'm not a professional, but in my opinion, that would seem like it would be more of an impact.
Does that blend in with the character of the neighborhood that you've got there?
No, the character of the neighborhood is single family residences.
Are there any other types of structures in that area or other types of uses?
I am not aware of any at this moment.
Okay. So is it your opinion that there's no other reasonable use with less impact on the critical area for that area?
Correct.
And so it satisfies prong 2.
Correct.
Okay, prong 3 is whether the proposed development poses an unreasonable threat to public health, safety, welfare, and whether or not development of that site is consistent with the general purposes of Chapter 21A 50 and a public interest. But again, apologies in advance, there's a lot to unpack under this one, so we'll go through it. Can you tell me sort of how the city goes about addressing that in this instance? I know that the Riley Group report is sort of what kicked it off, but what was your analysis to make sure that RUE is appropriate under this prong?
Yeah, so we generally tried, and we have in this instance sent to a third-party geotechnical services consultant, and they reviewed the application and determined that the property or the proposal was feasible, and they gave few recommendations as stated earlier by Jeff Whale, and would like to see further analysis when the actual building permit does come in for review. But at this point, his expertise determined that this application seemed feasible.
Okay, and is that how you, with critical areas of this nature, is that how you typically go about assessing whether or not it poses a threat? You defer to a geotechnical expert?
Yes, depending on the site, it's usually either some consultant of some kind that has expertise in a certain field, as a wetland or biologist for wetlands, or a geologist engineer for geotechnical reports.
And so is there anyone on staff at the city who could do an appropriate review of the the Riley Group's report?
Not in the planning group, and that's why we deferred to our consultant.
Okay. And you mentioned earlier that there's additional criteria that'll be addressed when the building permit application comes in. Is there a possibility that that could get rejected and that this plan as proposed could be rejected by the city at that point?
It's possible. I mean, depending on what's proposed and what is actually in the code at that time when the application comes in. Currently, we are in a building moratorium, so the application can't even be submitted at this point for a building permit.
Okay, so again, to talk about the RUE, this is just the first step in a process, correct? Okay,
Right.
So we're not approving a specific site plan. We're looking to see if it's feasible, whether it's dangerous, whether it's in line with the chapter for the critical areas, correct?
Correct.
Okay, and when you were talking about whether or not an unreasonable threat is posed to health and safety, I thought that you noted that tree retention was important to you. Why did you note that in the staff report?
Tree retention is important because it helps increase slope stability. In addition to the slope stability, I mean, the entire parcel will have an erosion or sediment control plan, a vegetation management plan, and stormwater pollution prevention plan prior to the building permit issuance.
And so to be clear, you haven't seen and reviewed all those plans. That's the next hurdle that these applicants have to go through, correct?
Correct.
But those are all required to be signed off by the city before a building permit is issued, correct?
Yes.
Okay. So is it your opinion then that it meets prong 3 of the RUE criteria?
Correct.
Okay. And then prong 4 is that any alterations to critical area buffers are necessary and any alteration is subject to conditions. Do you recall your analysis under this prong?
Yes.
Can you sort of talk us through your analysis?
Yeah, so we will review the building permit application when it is submitted, and the house appears to be one of the footprint anyway. It seems to be one of the smallest in the neighborhood from the surrounding homes. The rest of the property will be undisturbed and will remain forested. So with these, we believe that the house was a reasonable use for the property.
And I note that in your staff report, you mentioned that where it is in the property is important. Can you explain why that was? That it was located in the southwest corner of the site?
Yeah, because that would be the least detrimental to the site, and provide the best location for the building to be located.
Okay, you said that clearing limits have also been reduced to reduce the impacts to trees and vegetation, and it'll remain forested. How does that play into this factor? I know we talked about it in terms of factor 3, but what about factor 4?
I'm not sure what I understand the question.
Oh, okay, never mind then. And so in your opinion, does it meet the criteria under category 4?
Yes.
Okay. Is there anything that you've heard today in terms of testimony from either Mr. Kendry or the expert that you hadn't heard before?
No.
Is there anything that you'd heard today that would make you change your opinion on whether or not this property is appropriate for a reasonable use exception?
No.
Okay. I want to talk just briefly about Exhibit 310, the neighborhood analysis table. And I don't think we need to pull it up on the screen. I just wanted to talk to you about how something like that is created. Is that something you did or the applicant did? Or the city did? Is it something the city does or the applicant does?
Yeah, that's an submittal item as part of the application.
And are these properties cherry picked by the applicant, or is this a pretty random sampling of what's the actual surrounding properties are?
This is a pretty accurate description as to what properties surround this particular parcel.
And when you reviewed this, does the square footage proposed by the applicant seem out of line with what's in the neighborhood currently?
No, it seems to me as on the smaller side.
Okay. I'm just checking my notes. I don't think I have any further questions for you. Thank you.
Thank you.
Thank you. Mr. Willett, are you going to cross-examine on behalf of the appellant?
Mr. Gillette, yes, I am.
I'm sorry, Mr. Gillette. My apologies.
That is perfectly all right. Much worse has been done to my name. Mr. Johnson.
I'm sorry, I'm having a hard time hearing you.
Are you? Is this any better?
Yeah, that's a little bit better.
Okay. You testified that you stand by the city's response to the public comments. Is that right?
Yes, we sent the public comments to the applicant for them to be addressed, and the applicant provided feedback with those comments.
Okay. And are you familiar with the comments submitted by my office on behalf of the appellant, the Kendrys?
Yes, I do.
You are familiar with that? I don't. Is there an exhibit number on that? I don't have an exhibit number. I don't know what the exhibit numbers are.
I have City's Exhibit 7 as the public comments on the application. It's 49 pages long, so.
So this is I'm referring to a three-page letter.
Let's see, let's look at Exhibit 7, beginning at PDF page 10. Let's see if that's it.
Oh, yeah, it might be several of the comments, yeah.
On a minute. Did I say, oh, Exhibit 7, I'm sorry, let me click the right thing here.
The hearing examiner is correct. There's a letter by you in Exhibit 7 on page 10 of the PDF.
Okay, so and those are the comments that were submitted on my office submitted them on Mr. Kendry's behalf. And you're familiar with those comments, Mr. Johnson?
I'm just to be, we reviewed all the comments on what was provided as part of the public record or public comment period. So that would include your comments.
So what was the city's response to the comments on Exhibit 7, pages 10 through 12?
I do not recall a specific what the exact comments were back to the applicant. I'm not sure at this time.
And if I could interject, there's a staff review letter. I know Mr. Gillette said he didn't have the exhibits in front of him. The staff review letters are marked Exhibit 9, if that would be helpful to anyone pulling them up.
Well, I'm asking, just to be clear, Mr. Johnson, I'm not asking for, all I'm asking for is what was the city's response to Mr. Kendry or to this office on Mr. Kendry's behalf regarding the comments on Exhibit 7, pages 10 through 12.
I don't have them right in front of me. I can't speak to exactly what comments you're referring to.
If I can interject, excuse me, can I interject for a moment? The actual letter is on pages 10 and 11 with the signature block at the top of page 12.
That's correct.
Exhibit 13 is an attachment, or page 13 is an attachment.
Oh, that's
text
right.
Of the text on pages 10 and 11, the subject matter that begins under the subheading on page 11 is all about the easement, and I've dismissed the easement allegations from this appeal.
Yes, I understand that.
Okay.
So I'll narrow my question.
Yeah, you're really asking him to talk about your allegation that it didn't meet the criteria.
That is correct. So, Mr. Johnson, are you aware that in the comments that my office submitted on behalf of the Kendrys, that it was stated in there or argued in there that that Lingering Pine LPI had not met the criteria for a reasonable use exception?
I'm not exactly sure what you're asking. That's why we have the staff report that we indicated the public comments and addressed them as so in there.
Did the staff report, I'm asking about staff report, not about the applicant. Did the staff report respond to the comment in Exhibit 7, page 10, and going a little bit over onto page 11, that Lingering Pine had not shown that it met the criteria for reasonable use exception?
There was a general reference to, but not a specific relation to what you're saying right now as to what the comment was.
So when you say there was a reference to, what was the reference to? There was
That
a
we
reference
received
to.
public comment, and that we addressed the what were the concerns of the residents or the commenters.
Okay, one of the specific comments in that comment letter, beginning on the bottom of page 10 of Exhibit 7, the last sentence, this refers to the driveway. This would present the location of the driveway. This would present a significant risk of injury to the Kendry family and their guests, as well as pose risk of damages to their property. Did the city respond to that concern?
I'm not sure. Offhand, I can't make that determination. It seemed to me, as from what the Kendry's from Mr. Kendry's comments were, that most of it had to do with property rights. So I can't recall what exactly was stated.
Well, this was not a statement about property rights. This was a statement about the impact on his family of putting the driveway in that location. Comment about property rights came on the next page, and as the hearing examiner pointed out, that's not part of this hearing.
Correct.
But the
And
other
that
issue,
was
go ahead.
The driveway location, it was determined to be the best location for the proposed driveway, as the applicant has shown that there was a legally established easement for ingress and egress.
But you don't know, from your earlier testimony just a moment ago, you're saying you don't know if the city ever responded to the Kendry's concern that driveway location put the Kendry family and their guests at risk of injury, and that it possibly would pose a risk of damage to their property. That's what you testified to, correct?
I'm and I apologize, and I don't know. I'm having a really hard time hearing you.
Okay, what I'm asking is, I understand. I'll back up a little bit. I understand that you just testified now, or very recently, that the city determined that the driveway location was the best location because the applicant had an easement for ingress and egress over that land, correct?
Correct.
That was the city's determination. But the city did not evaluate, as far as you know, the Kendry's comment that putting that driveway there poses a risk, a safety risk to their family and to their guests, and a risk to damage of their property. As far as you know, the city never considered that comment or responded to it. Is that right?
But it never really, from my understanding, is Mr. Kendry's comments were basically he feels that it causes, or it could cause harm, not necessarily provided proof that it would.
Well, who has the burden of proof in establishing whether or not a reasonable use exception is to be granted?
But you're talking about the access easement. I'm talking, well.
No, I'm not talking about easement. I'm talking about the driveway.
Okay.
There's not a driveway there today. The courts have determined there's an easement. There is no driveway there today, is there?
No, there is not.
So it's the applicant's idea to put a driveway in there, and the city says they think that's fine because the applicant has an easement. But there is no driveway there, so that's, if it's going to happen, it's going to happen in the future, right?
Right.
And the Kendrys have expressed concerns for their safety and their children's safety and their guests' safety and for the risk of damage to their property, right?
I guess I'm not understanding what you're asking
Okay,
for.
well,
Because the review of the building permit will indicate the what is going to be established for the driveway access.
okay, well, we'll get back to this as we go through some other parts of your testimony.
Okay.
Um,
Sorry, I don't know.
let's go to the city's analysis of criterion number 3. So the criterion number 3 requires consideration of unreasonable threats to public health, safety, or welfare, correct?
Yeah.
And it requires analysis and consideration of threats, of those types of threats, both on-site and off-site, correct?
Yes.
And so if there's a concern about safety impacts to another property, that would be something that should be considered under criterion number 3. Is that right?
I would believe so.
Right. And it's appropriate under criterion number 3 to consider such safety concerns. Is that right?
Yes.
And if there are concerns about damage to property, physical damage to property that belongs to somebody other than the applicant, that would be another off-site impact that should be considered under criterion number 3. Is that right?
Yes.
And we go to Exhibit 1, which is the Riley Group Geotechnical Engineering Report. They never addressed anywhere in that report the question of whether or not that driveway, located as close as 4 feet to the Kendry house, would pose a threat to the safety of the residents of that house. Did they?
I'm not aware.
Does that mean it might have considered it?
I couldn't remember I can't remember offhand.
Do you have Exhibit 1 with you?
The geotechnical report?
Yes. Mr. Johnson, are you waiting for me?
Oh, yeah, sorry. What did you want me to specifically?
I was asking if you have a copy of Exhibit 1, the geotechnical report, with you.
Yeah, I'm trying to pull it up right now.
Okay.
And in the meantime, what exactly are you?
Well, my first question
wanting me to comment on?
My first question is going to be if there's anything in Exhibit 1 that considers or analyzes or discusses in any way any potential risks to the safety of the Kendry family household or their guests resulting from a driveway that located in that easement.
Okay. Sorry, this is a very long report, and I can't pinpoint where, if any, are in here.
You don't. Oh, go ahead. Go ahead.
The professional report we received from Jeff Whale of Robinson Noble, they just stated that that safety design and was taken into consideration, and a residence could be built on the property that we are talking about now.
Okay, well, we'll come to Mr. Wales' report in due order, but I want to talk about the geotechnical engineering report by the Riley Group. And you've not identified for me or for the record any statement or analysis or discussion in there of potential safety impacts on the Kendry family or their household, or their resulting from the location of the driveway and that easement. Correct? You've not pointed to anything like that, right?
I'm not aware of any in here. I could be mistaken on that, but I cannot pinpoint a specific reference to that.
Well, with the indulgence of the hearing examiner, if I may, I'd ask that the witness be given the opportunity to spend as much time as he can looking at the exhibit in order to answer my question.
I'm not inclined to do that. I recognize from his testimony that apparently Mr. Johnson didn't come on board with this project until last February, give or take. But that's 5 or 6 months ago. We've known about this hearing for a couple of months. I believe all parties have had ample time to familiarize themselves with the documents that are relevant. And I see no reason why I should sit here for an hour while he looks through a 40-page report. So I'm going to decline that invitation.
All right. Well, thank you. I'll ask the kind of a similar question, but of course I won't ask the witness to read through the entire document. But just to get it on the record, with regard to the concern expressed in the Kendry comment letter from this office, that there would be safety, or excuse me, not safety, but there would be potential impacts to the Kendry property from the location of that driveway. Do you know, sitting here, whether or not that concern was addressed in the geotechnical report, Exhibit 1?
I'm sorry, can you repeat that one more time? I was trying to.
Sure.
Need some more.
You know if Exhibit 1 examines or considers the concern expressed by the Kendrys in their comment letter that the location of the driveway could adversely impact their property.
Are you requesting, are you asking whether the report indicated that, or are you saying, I'm sorry, I'm so confused by what you're what you're
This
asking.
is Mr. Walker. I mean, I feel like I need to step in and object because Mr. Gillette's asked this question several times, and I think Mr. Johnson already answered it to the best of his ability, and even stated earlier that this would be reviewed at the time of plan submittal. So I don't think we need to spend a whole lot more time on this.
Let him
I don't know.
let him finish his objection. Mr. Walker, let me confirm for the record, sir, are you or are you not an attorney at law?
I am an attorney at law.
Okay, he's filed an objection. Mr. Gillette, do you wish to respond to the objection?
Only that I don't believe that I've gotten a clear answer to that question yet. I've gotten a very confused answer. And all I'm asking now is just to be clear, is that he give me an answer based on his present knowledge. I'm not asking him to review the document.
Ms. Graber, do you wish to respond to the motion, to the objection?
I agree with the applicant's attorney. I've heard this question asked a number of different ways. If he can't answer, he can't answer.
Okay. I concur. Objection sustained. Back to you for further questions, Mr. Gillette.
Yes, thank you, Mr. Galt. Let's take a look at the peer review report from Robinson Noble. That's Exhibit 8. Mr. Johnson, I believe you testified a few minutes ago that in the Exhibit 8 that Mr. Whale concluded that the proposed project would be safe. Is that accurate? An accurate description of your testimony?
It was the geotechnical review stated that the what the applicant was proposing could potentially even more so stabilize the hillside, and that the project was feasible.
Okay, but when you made that reference in your earlier testimony, you were talking about about the effect on the slope and that it would be safe and feasible from the point of view of slope stability to put the project in. Is that right?
Yes.
Were you here earlier when Mr. Whale testified?
Was I present? Yes.
And were you able to hear my questions and my cross-examination and his answers to my questions?
I honestly have had a hard time hearing you throughout the whole entire process. I don't know if maybe it's my speakers, but I mean, I haven't had any issue with anybody else's testimony or their voice volume, but I'm honestly having a hard time hearing you and understanding and getting a whole good grasp of what you're saying.
Sure. Well then, I won't assume then that you were able to hear the earlier testimony.
Can I make a suggestion? Can I make I don't know that it's fruitful for him to answer questions he can't hear. Mr. Johnson, is it possible for you to dial in so that you can actually hear the questions being posed to you? Could you maybe call in? I don't want to continue. If it's a technical problem, I don't think we should continue if you can't understand. Maybe that might be part of the problem here.
Yeah, I can call in. Just give me 1 second.
Yeah, I think that's wise.
While we wait for him to call in, when these online hearings work well, I leave the process and think, maybe this is the way we ought to do it all the time. It's more convenient. Nobody has to go to City Hall. We can all stay in the comfort of our home or our work office or whatever and take an hour or two and get together. And isn't life wonderful? And then we get a hearing like this one with all kinds of technical,
Right.
and I'm thinking I can hardly wait until we can get back to doing these in person.
I have to agree entirely.
When it works, it's beautiful. And when it doesn't work, tain't so good.
Right.
I don't see another indicator popping up on my screen. So I'm wondering, maybe Mr. Johnson's had to go try and find the phone number to call. I know I wouldn't know it. I think it's on the public notice thing somehow or other.
I think it is.
I'll give this a couple more minutes and then I think I'm going to insist that we move on. We may have to come back to this for you to pick up with Mr. Johnson.
That would be fine. We have to make adaptations to the circumstances, obviously.
Yeah. I've taken witness here. Maybe he's coming now. Something's happened. Oh, he's left. The corner of my screen says that he left.
I think that's a good sign. If we need, somebody's back in. I was
Here's
gonna
number
say,
30. Here's attendee 30 just joined. I wonder if that's Mr. Johnson. Is that you, Mr. Johnson?
This is me, Mr. Examiner.
Okay, we have Mr.
That is
Johnson
me.
back. Mr. Gillette, say something to it.
Okay, Mr. Johnson, and can you hear me better?
I can hear you a little bit better, yes. Thank you.
Okay, well, if I ask a question and you don't feel that you heard me well enough to answer, please tell me that, okay?
Okay.
So,
thank you.
You bet. So we were looking at the Robinson and Noble peer review report that Mr. Whale prepared. And I'd like you, if you have that exhibit, it's exhibit 8. I'd like you to take a look at page 3. Let me know when you're there.
Okay.
Okay, and do you see that on that page there are 3 of the paragraphs have bullets in front of them? Yeah. I'd like to direct your attention to the 3rd bulleted paragraph, and I'll read it into the record. The report indicates that 10 feet of, excuse me, I want to clarify that the report that this is referring to is the technical information report, not the geotechnical report. Okay, so the report indicates that 10 feet of flow path exist for sheet dispersion from the planned driveway accessing the site. Our review of project plans does not indicate that this 10 feet of flow path exists between the driveway and the northern extent of the access easement. Were you able to follow that, Mr. Johnson?
Yes, I understand what it's saying.
Okay. Can you summarize for us what your understanding is that it's saying?
That there will be stormwater collected on the driveway, and they need to be dispersed through the flow path of the stormwater.
And where is that flow path? What is that flow path? Whose property does that flow path flow over?
To be honest with you, I'm not a engineer, so I can't speak to the exact water dispersion techniques or review of the application.
Well, the bulleted quote that I read to you says there are not 10 feet of flow path between the driveway and the northern extent of the access easement, right?
Yes.
And the driveway
Our stormwater team will do the review of that, of what you are bringing up now as part of the building permit review.
Okay. All right, that's helpful to know. Let me just offer as a hypothesis for you to consider that if you just had the flow path follow its natural course, the 10 feet would actually be off the easement on the Kindry property. Okay, let's assume that to be true. If that were true, or if a risk of that were true, would that pose a threat to the public health, safety, or welfare off the development proposal site?
I'd like to insert an objection. He just stated he's not a stormwater engineer with no expertise in the area.
Well, he's testifying here. May I respond to the objection?
Okay, go ahead.
He's testifying here on behalf of the city, which made a decision about what factors to consider in applying these various criteria. And I'm basically trying to find out from the city's point of view, through the city's witness, whether or not this potential impact on the Kindry property is the type of impact that fits under criterion number 3.
The extent that that's the purpose of the question, objection overruled. To the extent that you're trying to get an expert drainage opinion from the witness, I would sustain the objection.
And you correctly characterized the purpose of my question.
Mr. Johnson, you want him to?
Well, I don't want to assume anything. I mean, we will do a full review for conformance to the stormwater code at the building permit review.
Let me try to ask the question in a way that doesn't require you to assume anything. Our impact to our physical impact to off-site properties among the types of concerns, or the types of issues that are threats to public health, safety, or welfare off the development site, as that phrase is used in criterion 3.
That will be part of the review of the building permit and take that into consideration.
Well, Mr. Hearing Examiner, I would ask that the witness be directed to answer my question. He's answering his own question.
Now he's giving you his answer to your question. It may not be an answer that you expected or wanted, but it's his answer.
So then, so the city did not consider this impact under criterion number 3. Is that right?
The city will conduct a full review under the building permit.
Now that
Right, and that has not.
that I will jump in on this one. Mr. Johnson, that answer was not at all responsive to the question that you were asked.
Okay, I'm just trying to understand exactly what the Mr. Gillette is asking. I'm sorry. Stormwater runoff is, a general concern for any project site, and we will address that.
I'm asking if it's accurate to say that the city did not consider it in connection with its evaluation of criterion number 3.
We were under the assumption from our consultant that the project was feasible, and they were provided a site plan of the overall scope of the project, and based off of their review, we determined that the project was feasible.
Your Honor, Mr. Hearing Examiner, that does not answer the question, and I think the question is pretty darn simple.
I think the question's simple too. I think he has given you a sort of an answer. May I suggest just move on?
Okay. Let's go to criterion number 4, and you testified on direct examination that the city. I'm gonna, and I don't mean to do this, but I'm gonna put words in your mouth. So don't let me do that if I do it inaccurately. But my understanding is that you testified the city concluded that the applicant met the requirements of criterion number 4 because, or in part because the footprint of the proposed building is in line with similar footprints in the neighborhood. Is that right?
Yes, in part, yes.
Okay. Now it is also accurate, is it not, that there are in the neighborhood house footprints or building and living space footprints smaller than the proposed project. Is that right?
That is my understanding, yes.
So it would not, the proposed project would not be the minimum footprint in the neighborhood, would it?
It would not be the minimum footprint, depending on the vicinity of the neighborhood, what you're referring to.
Well, let's just use the neighborhood that the city used to address and to consider this criterion. There were smaller footprints that the city looked at, correct?
Correct.
So if a smaller footprint would it be possible to put a building on that site with a smaller footprint?
It might be or it might even be that during building permit review that the applicant has to submit a smaller footprint just because of the setbacks that would be in place at that time, because the RUEs don't vest to a certain code for development review. So this was just based off of what was at the time, the setbacks.
Okay, but the city, at the time the city made its decision in May of 2020 to approve the RUE application, the city knew at that time that there were footprints on lots in the neighborhood smaller than the applicant's footprint, correct?
Yes, correct.
So at the time or before approving the RUE application, would it have been possible at that time, whether or not it was required, I'm not asking you, but would it have been possible for the footprint of the building footprint to be smaller than it was in the application?
Yeah. So the footprint is not the footprint is not the smallest in this neighborhood, but it is not also even an average of the neighborhood as well. It's basically an average on there to provide guidance as to what kind of footprint it has been generally built in that specific area.
I have no further questions on cross.
Thank you. Mr. Walker?
Yeah,
You got any questions for this witness?
I have some questions for him, but they're not really cross-examination. I guess they kind of are. So I just have a couple of questions for you, Mr. Johnson.
Sure.
Exhibit 3.13, that's a site plan. And again, I'm not a stormwater engineer, but is that a site plan that shows the drainage or proposed drainage for the subject property? I'm just trying to get to Mr. Gillette's sort of answer his earlier question in a way.
Mr. Johnson, take your time and pull it up if you need to.
Yeah, it's downloading. Sorry.
Since Mr. Johnson has called in, would it be fair to request somebody else to upload the image from the plan set and I could set them as presenter?
I don't care how we do it.
I can do it. Do we need to share it? I just want it in front of Mr. Johnson if he's going to be asking questions about it.
I don't know why.
Yeah, okay. It just pulled up. So
when I just tried to bring it up on my computer, I got something that said I had to do a PDF download, which
it's
I have.
It's a large file. Do you want me to share it? I have it up. I can share it.
My questions really aren't going to be specific. I just want to know, Mr. Johnson, if this was submitted as part of the file, what it shows, and if the city took this into consideration when it made its decision. Those are my only questions.
Yes.
So what type of each question individually? Objection.
Sure. I'll ask the questions individually. Can you give me just your general understanding of what this document 3.13 is, what it shows?
Yeah, it's the stormwater control and post-construction soil management plan.
Okay, so was this submitted as part of the applicant's application?
Yes.
And did the city take this into consideration when making a determination? for the RUE?
It was reviewed for some. It wasn't fully reviewed, as this would generally be part of the building review. That stormwater would be reviewing this, but it was a submittal item from yourself at the applicant.
Okay. It'd make me feel a lot better if you said you reviewed it, because I spent a lot of money on it. So never mind. So the other questions that I had for you regarding square footage of neighboring properties in the neighborhood, would it surprise you to know that the neighboring Mr. Kendry's house is 3,850 square feet, Miss Leslie's house is 4,420 square feet, and another neighboring property just adjacent to the subject is 4,290 square feet? Not the footprint, but rather the square footage, because I don't know what the footprints of those houses are. But would it surprise you that there are other homes directly close by that are larger than the proposed one here?
Would it surprise me? No.
Okay. Just given your understanding of the neighborhood and the types of homes that are there.
Yeah, and city of Sammamish in general, yes.
Okay, that's all I really had. I was just trying to answer Mr. Gillette's earlier question about the drainage and stormwater runoff, and so that's why I was pointing to that one particular document. That's all I had.
I have two follow-up questions, if I may.
Before you do, I've got a couple I'd like to ask. Johnson, what is your understanding of what the acronym AGLA stands for?
I had never heard of it prior to this, but if it was, I'm blanking right now what it was. Average or I'm blanking.
So you don't know what it means?
It's not a commonly used term.
Don't feel badly if you don't, because I don't know what it means either. That's why I'm asking you.
Right. Yeah. It's not a commonly used term, at least within the city of Sammamish. So I don't know exactly what it is. So.
Okay. Do we have in the record the living area square footage of the proposed LPI residence, or do we have only the building footprint square footage? Or do we have both?
As far as I can recall, it was just the main building area.
Building footprint?
Yeah.
Is it your understanding that these footprint numbers that have been tossed around in our hearing today and that appear in the record documents include a garage?
The average or the impervious surface.
I'm not asking that. I'm asking building footprint.
I'm sorry.
But it started at 1,400 something square feet and it's up to, I think, 1,680 something or other, or something like that. Is it your understanding that that includes garage?
Yes.
Well,
yes. Sorry. Was that, did that get registered or heard?
Yes, I did hear you. Thank you.
Okay.
Is the entire LPI parcel, excluding the easement, I'm not talking about the easement, is the entire parcel a landslide hazard area?
within the landslide hazard and hazard buffer, yes.
I didn't ask you about the buffer. Please answer
Okay.
just the question I asked you. Is the
Sure.
entire site a landslide hazard area?
My understanding is that it's not the whole entire site. There's just a small section in the southwestern portion of the parcel.
Small section in the southwest portion that is a landslide hazard area or is
Is
not?
not.
Is not. Okay. When I add the required buffer to the landslide hazard area, is there any unencumbered property left on this site?
No.
If I reduced the landslide hazard area buffer to the 15-foot minimum allowance, would there be any unencumbered land within the lot?
I mean, without having like anything proposed in front of me, I can't really make that determination, but it would not seem like it would be feasible to place a house on the property with even just your general development standard setbacks.
Is there a graphic in the record that shows us the extent of the 40% and greater slopes on the property? In other words, is there a graphic in the record that shows us where the top of slope line is?
I believe so.
Because if there is, then we can answer the other two questions I asked definitively. Lickety split, put a scale on it and you got the answer. I haven't seen one.
Well, all the site plans are on a topo map. So they do have the contour lines and the elevations on them.
And who's this? Who's attendee 22?
All right, so this is the applicant. I'm just saying all the site plans are
That's
overlaid
fine.
over a topo.
Sir, Mr. Walker,
Sorry, I'm just trying to speed things up here. I don't.
having the you're not making things faster. Having the
Sorry.
topo doesn't tell us where the top of the 40% slope line is. I'm physically and mentally capable of calculating it myself, having the experience that I've got. But to do it, I have to have an accurate at-scale drawing, and all I have is electronic copies. So it's not a crazy question to ask. Is there actually a graphic that shows the extent of these critical areas? And to what I remember seeing in the record when I reviewed it, there is not. And that's why I'm asking to see if I missed something. Mr. Johnson, you don't think I missed anything then? There's no map that shows us where the top of slope is that right?
From the landslide hazard area, I am not aware of any.
And to expedite the process, I can submit one when I redirect.
The applicant submitted one? Or are you talking about submitting the city maps? Because they're in the staff.
I have a snapshot of the city map up right now. I can make it city's exhibit 20.
I don't know what Mr. Johnson's answer is going to be, but I will tell you that over the years, I have had sworn testimony from city applicants in numerous cases telling me that the city maps cannot be relied on for a lot by lot determination of the edge of a critical area. That they're generalized maps. And they're in the record here. I'm asking whether there's specific determination made. I guess the answer is no. Would the same answer be applicable for erosion hazards and the CARA, Mr. Johnson? There's no specific map?
I'm sorry.
There's no specific map in the record?
I know we have a map showing the erosion hazard and CARA. I'm not 100% sure if it is in the record, but we are in receipt of one.
From the applicant?
Yes, sir.
Oh. That would have been nice to have in the record. Before I don't want
If I
to read
can,
any
it is the erosion hazard area is illustrated in Exhibit 5, City's Exhibit 5. And the CARA area are both delineated there. If you're having problems pulling it up, I can share screen.
Now I've got 5 pops up quite well. Whether I can read it's another question. I'm enlarging this bigger and bigger and bigger, and the text isn't getting any clearer.
Shall I share screen? I have it pretty big.
Okay, I am now seeing it.
Okay.
There's erosion area only is an angled line, and the erosion and CARA is a crosshatch. Am I reading the legend right? I'm on sheet
Correct.
3.
Yep.
Okay. Then I've got to reduce the size of it in order to be able to see the left edge. Okay. I see. Okay, but that doesn't tell me about the slopes, does it? So I'm still missing that piece of information. 5, 3. Okay. To the best of your understanding, Mr. Johnson, when the folks are talking about the site containing 0.41 acres, are they talking about just the lot? They're not talking about the area of the easement, are they?
Correct.
Okay, thank you. And when the documents talk about the impervious area being 2,934 square feet, is that talking about just the impervious area on the lot or the impervious area of the lot together with the driveway?
My understanding is it's just on the lot,
Just on the lot. Okay, thank you.
Mr. Examiner.
Thank you. Okay. I don't have any other questions. Ms. Graber, you wanted to ask some further questions of your witness?
I do. I have a little follow-up just to clarify some of the questions I've heard lingering. So, Mr. Johnson, if I could direct your attention to page 1 of Exhibit 5 and let me know when you're there.
Sorry, I'm downloading it right now.
No problem.
You said page 5?
Page 1 of Exhibit 5.
Oh, I'm sorry. I misheard you. Okay.
So I know there was some confusion about what constitutes the total square footage. If you could direct your attention to the top left corner, do you see a box that says impervious surface calculation?
Yes.
Does that box talk about what is included in terms of driveway in terms of vehicular use areas, patio, total impervious surface?
Yes.
Okay. And the
Excuse me. Just for what it's worth, for some reason, on my computer, when I enlarge that exhibit, the left edge disappears off the left side of the screen, and I'm not allowed to pull it over to the right. So I cannot read anything that's on that left column of numbers on that first page. Because
do you want me to?
When I get it big enough to read it, it's gone off the screen.
Would you like me to have him read those numbers into the record, or do you want me to share a screen so you can see it?
If you can share a screen, that might be wonderful.
Sure. Ms. Beatty, could you allow me to do that, please? I will just zoom way in so we can all see it for the record.
I believe you are already listed as a presenter. Is it not? Is this screen share function at the bottom?
Got it. Doing it. Thank you.
No problem.
Okay, so you should be able to see this area right here. I'm circling it.
I see it, but I can't begin to see what's in it.
Oh, really? Okay, let me zoom in for you. So
it's way too small.
Oh, okay.
I don't know
zooming. I have to.
What screen you're looking at, but mine's a laptop. So.
Oh, okay. Is that a little better? Am I getting there?
It's a little better.
Okay. Well, I'll defer to you then if you think it's wise to have just rely on the record itself. But I did want to answer the questions regarding what sort of square footage we're talking about, because this is all, it's all listed in this exhibit.
And I do appreciate seeing that.
Here, I'm going to zoom in one last time and make it as big as I can.
No, here's a thought. I'm going to be leaving the record open for a period of time so that people can respond to the new exhibits that came in today. Okay? Can we get somebody to print a paper copy of this page and just mail it to me?
I don't see why not.
I hesitate to say mail it to me because I might have the same problem when I get it in a different form. But when I get it on this, for some reason, I enlarge this thing and the left side of that particular image just plain disappears off the left edge of the screen.
How bizarre. Okay, make sure you can get a legible copy.
Yeah, I'm doing that on my laptop screen, which is about 20 inches wide. I'm still losing it.
Yes, I can certainly get a copy of that to you somehow, some way. Maybe I'll put it into a PDF or something. Okay. So the acronym that we were talking about earlier, AGLA, you said you couldn't recall. Do you believe it stands for above grade living area? Does that ring any bells?
If that's what the, I believe so.
Okay.
But I don't know that term, so.
Okay, if you don't know, you don't know. I was trying to trigger something if you could recall, but that's fine.
Ms. Graber, do you want to be sworn in?
I do not. I know. I have no desire to become a witness.
Maybe somebody else will know.
Yeah, well, it's worth asking. Okay, talking about whether or not the city considered the danger posed by the driveway, as the attorney just a moment ago asked you, the danger alleged by the appellant. Can I direct your attention to Exhibit 10, page 3? Let me know when you're there.
Yeah, I'm headed there. Page 3.
Yes.
For the record,
Here.
can't get it to come up. When I was reviewing the files, it came up fine. The computer system is now telling me I have to do a PDF download and all kinds of garbage to get it. So I'll look later.
Okay, I'll read it into the record. So first, Mr. Johnson, what is this document?
It's the response to public comments from or the response to Michael Gillette on behalf of Rupesh and Susie Kendry. Comment dated November 19th, 2018 via email.
So is it correct to say that in regard to the questions you were asked earlier, the city itself didn't respond to that public comment, but the applicant did and submitted that to the city?
Correct.
Okay, and I'm going to read this into the record for Mr. Galt's benefit and anyone else technically challenged. Do you see the part that says the access easement that exists over the Kendry property is no more dangerous than any other private road? A fence can be constructed on the Kendry property if they have safety concerns. Do you see that?
Yes.
And is that statement something that was submitted to the city before the city ultimately made its decision on this matter?
Yes.
Okay. Is it true that structural review occurs before the building permit stage and not the reasonable use acceptance, reasonable RUE phase of development?
Yes.
Okay, and do we typically do stormwater reviews as part of an RUE?
Yes. Or, sorry, what was the question again?
Do we typically do a stormwater review as a part of an RUE?
No.
Okay, no further questions.
Do either of the other principal parties have any questions they wish to ask in the form of recross relating to the limited topics that Ms. Graber just had the witness discuss?
This is Mike Gillette. I have none.
Thank you,
I
Mr.
have
Gillette. Thank you, Mr. Walker. Thank you, Mr. Johnson. And thank you for jumping onto the phone to make your communication with Mr. Gillette work better.
Thank you, Mr. Examiner.
Mr. Hendry, I do believe, if I'm recalling where we are in this whole crazy sequence today, that the question still is, do you have any additional witnesses that you wish to call?
I do not.
Does not. Thank you. So the appellant rests. Respondent city. Have we exhausted your witness list? We've already had the primary ones, I think. Do you have?
Yeah,
other...
I'm not going to call Miss Beatty. I think all the subject areas have been covered, so the city would also resume and rest.
Okay, thank you. Mr. Walker, do you have any witnesses that you wish to call?
I have no witnesses, Mr. Galt.
Thank you, Mr. Walker. We are at the point where the rules say we can have public testimony. What I'm going to do is take a look at the boxes on my screen and skip over the ones that I'm quite convinced are city employees or the wife of the appellant. And if I skip over you and you really are somebody other than who I think you are, please reveal yourself through the video and I'll come back and pick you up as a witness. We know that Ms. Beatty is a city employee. I believe attendee 6 is Ms. Hatchie, who's a city employee. At least she was this morning. I'm assuming Ms. Kendry is Mr. Kendry's spouse or relative in some fashion. I believe Ms. Mueller is a city employee. Mr. Walker is the applicant and his attorney. I believe Mark Newman is a city employee. Does Dawn Lovely wish to testify?
Hi, yes.
You do?
Yes, I do.
First, do you wish to testify?
I do.
Okay, would you raise your right hand, please? Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. For the record, please state your name and how to spell it.
Dawn Lovely, DAWN LOVELY.
Okay, thank you, Ms. Lovely. You may proceed.
So I own the adjacent property. I have a double lot. So my lot is adjacent to both Rupesh Kindry as well as the lot in question by Mr. Walker. My concerns that I raised in a letter to the city that I don't feel were ever addressed was the fact that I had a geo assessment done for my property because I did an extension. The extension actually went over the property line. So my two lots are now combined into one lot. And so when I was doing this extension, I had to have this geo assessment done. My assessment stated I had to stay 30 feet away from the critical slope. I made adjustments to my construction plans. I was not able to do a double car garage extension. I did a single car extension in order to stay away 30 feet from the critical slope. So one of my concerns is the fact that we're allowing someone to build on a critical slope that I was being told to stay away from. And the testimony that I heard today is that all properties in the area are being referred to as similar, and they're not similar. This is on a very steep critical slope. Our houses are not on any kind of critical slope, so that's my concern. So one was my geo assessment that said stay away from it. Now we're allowing somebody to build on it. And then my second concern is the impact to my house, which is very close to the property line. I believe it's 5 feet. And my property is higher. And it's also kind of supported by a wall. So any construction on that lower lot, any kind of, moving the earth, before any kind of foundations are poured, I have serious concern of impact to the stability of the foundation of my house, which I also brought up in my letter and did not see that that was addressed either. So what I saw addressed by Mr. Walker in the geo assessment was, again, making statements that this house is no different than any other house in the neighborhood, but it didn't directly address the concerns of the stability of my house or the fact that my geo assessment said don't build on a critical slope.
Okay. Thank you very much. I generally don't allow cross-examination of lay witnesses, even in appeal hearings, unless they've been called by one of the principal parties. So I'm not going to subject you to cross-examination. Thank you, Ms. Lovely.
Okay, thank you.
The next on my screen is identified solely as attendee 22. Is attendee 22 there? Or is this one of these residual things where the box, like Mr. Walker's box, hangs around, but he's down on the telephone instead? Attendee 22? I'm going to pass you by. The next on my screen is Mary Wichter. Ms. Wichter, do you wish to testify? She does. Can we turn her audio on? There you go. And would you raise your right hand, please, ma'am? Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. For the record, please state your name and tell us how to spell it.
My name is Mary Victor, MaryWictor.
Thank you. Go ahead.
I am the person who sent in the 8 pages that was emailed, so I don't know if you want me to try to screen share while I do my public input or not.
Actually, I prefer you didn't go through the whole 8 pages. I'll have plenty of time to read it, and I'm going to leave the record open for the other parties to be able to read it and respond. So maybe what you could do, summarize it, hit the high points or something.
That's what I was planning on doing. So can everyone hear me okay? My name is Mary Victor. I've lived in Tamarack for over 20 years now. I live at the bottom of the hill. I've also will let you know that while I'm not an expert or an engineer, I have attended hundreds of city council meetings, read stormwater code, seen a lot of things, and my input is based on the code and the experience I've had over the last 6 years. The first thing I'd like to say is that a transfer of development rights does not appear to have been considered at all for this property. It is an innovative, non-regulatory program which is recommended by the Growth Management Act. I have a picture in my thing. I believe that this site, it is part of the Inglewood Sub-Basin and it could qualify for that. It's right at the edge. This lot is very unusual. It is constrained by erosion hazards, landslide hazards, steep slopes, critical aquifer recharge area, which is known as a CARA or CARA in a class 3. And there is also a drains 2 designation since 1990 through 1998, originally from King County of the landslide hazard drainage area. That has become regulated since the first day of 2017 in the city of Sammamish as a critical drainage area. This lot is very constrained by multiple overlapping critical areas, so it needs many limits. And just to refer to Jeff Wells, who spoke as an expert witness today, or on behalf of the city, this lot really has steep slopes where the other ones that are listed and used in comparison do not. And he also said that was what made it unique when Attorney Graber was questioning him. The second thing I'd like to say is this is not minimal development, and it has no mitigations that have been applied, and it is not modest. When the city approved this RUE, I have a sheet here in my feedback that has highlights. When you're looking at reasonable use scenarios, and this is from the Critical Areas Handbook dated 2018 from the Washington State Department of Commerce, who's involved in implementing the GMA, it says a reasonable use exception should be granted for a minimal development if the property is completely unencumbered and mitigation methods are applied. So you just don't do it because it's encumbered, but mitigation has to be applied. I'm also getting feedback from somebody's mic, but I'll keep going. It also says to be consistent with case law, you have to be careful of the use of the term reasonable, and the concept of reasonable has been left to the courts to decide. And it also says that reasonable use is often thought to be a modest single-family home. And from the meetings I've attended for the City of Sammamish, Mike Kenyon, as attorney for City of Sammamish, recently related this year that if there is not a term defined in regulations, that one would use the standard dictionary definition. So I've looked up modest. In the dictionary definition, it says of amount, rate, or level, relatively moderate, limited, or small. Therefore, this project is not considered a modest single-family home. Through the own comparisons, which were submitted by the applicant with it, it's trying to be like one of the other. And I would say if you're going to have to do an RUE for this site because you're not going to do a transfer of development right or anything else, that it should be maybe one of the smallest homes in all of Tamarack. And since I've lived here 20 years and I have gone through, I believe, almost every lot in the 210 lots, there are many homes that only have a 1,200 square foot footprint or even smaller, maybe 1,300, and a lot of them are one story. That is not atypical in Tamarack. I also don't think that it's important that an RUE tries to make up for everything that the other sites have, because this has multiple critical areas where some have none. Some have only one of the landslide, and if they meet those requirements, they can build. I also have a map on here which shows the steep slope areas. The city does not map steep slope areas, although I've tried to get them to. On the map and highlighted in yellow, you'll see the steep slopes start right at the brink of this lot, starting, I believe, from Don Lovely's property, which is why she made the comments that she did. There have been landslides that have occurred, and the city actually went through 5 emergency surface water ordinances from 2014 before I started speaking until 2016 for the Tamarack and Inglewood areas. Landslides have occurred. They've occurred in the George Davis Creek area below this home. They've occurred within Tamarack. They've occurred next to Tamarack. They've occurred within the band of Tamarack, including by my home. All of those have come from runoff or stormwater that has not been managed, which is why that is important to consider for safety, even when you're doing an RUE. And I have maps for that. Also, whenever you make the setbacks reduced or eliminated, it will impact the critical areas even more. If you have a larger or taller home that is allowed, it will add more weight to a steeply sloping hill that is also erosion and landslide, where most of the other ones in Tamarack are only landslide or not and do not have steep slopes, many of them. If you remove trees, which Andrew Johnson, as associate planner for the city, talked about, trees prevent rainfall by intercepting it and the precipitation. They have evaporation and transpiration processes, and if you don't have the trees, or if you take them out, including the stumps, you'll have erosion possibilities. You'll increase the groundwater level, seepage in the erosion area, and the appellant has actually provided photos that you talked through earlier about the impact he's seen in recent years on his property. So there is other reasonable use with less impact in these multiple critical areas. That would be a smaller house or project. That would be maybe a narrower driveway. Alterations permitted in critical areas or buffers shall be the minimum necessary, not equal to everybody else. They should be authorized alterations that are subject to conditions. The city needs to put conditions on it. And these include, but are not limited to, mitigation under approved mitigation plans. I do not see those in the record, nor that the city has considered those. My third item is stormwater concerns for drainage problems that's with issues and impacts to the area. While there is a drainage easement that's been given to the city that's 10 feet wide and it's recorded, there is also code violation showing that the stormwater work has not been done. Also, the work on Northeast 6th Street below has not been done, and this RUE just assumes that it's going to use it, and there is no flow control. You need to have flow control with the amount of impervious surface it is. Per RCW 3670A.20 planning goals, the city is supposed to encourage development where adequate public facilities and services exist and can be provided in an efficient manner. The item number 12 under that is those public facilities and services necessary to support the development should be adequate at the time the development is available for occupancy. The house below where they're maybe going to use a storm input, that is occupied, and I don't believe the stormwater is installed. Also, the city map for storm drainage appears to have things that haven't been implemented yet, so the city really needs to look into that. And you can say, oh, this will happen as part of the building permit, but the problem is if you're putting water and drainage into landslide and erosion hazard areas, you will increase the instability of the slope, and that will impact anybody who's adjacent, needs support downhill or at the bottom of the hill. So I really think that needs to be considered. Also, just on the city's behalf, they're spending $7.5 million on doing George Davis Creek improvements for salmon recovery. They're at the bottom of the hill, and if there isn't flow control done properly for this property, there will be additional problems down there, and there's already, city has records of landslides that have occurred in that area. For this house to build, it actually needs to have a approval from the director to have any core requirements or special requirements that are removed. And there have been codes I have advocated for that the city has adopted that say if you're in Tamarack, you have to use a tight line. You can't discharge anything other than a tight line system that is properly sized so that it would convey cumulative full build out flows. And the city has also adopted, actually was forced to adopt the King County 2016 Stormwater Manual so they would stop using the 1998 code. And in that manual, the 2016 King County Road Standards and Construction Standards are mentioned. On those, particularly for this lot, you cannot just let your driveway run into the private road. You have to do something with your water on your driveway. And the size of conveyance pipes and things for driveways are also part of the King County Road Standards, which should apply. And then my fourth and final point is environmentally critical area protection should avoid, minimize, and mitigate. That's in the code under title SMC 21A.50 for environmentally critical areas. So if you use the transfer of development rights in city for this lot, it would avoid building here. That's one way to do it. If a RUE has to be allowed, or if it's approved, it should be minimal development for a modest home with true conditions and mitigations, which I do not see. Water services available and sewer within 200 feet, so there should not be septic, which would also add to problems for this lot. Infiltrating practices for low impact development and best management practices should be infeasible. You can't just put the water into the soil. There's also a private water well, I believe, in the area, and you shouldn't be impacting those either. It is also a CARA Class 3 area. The access driveway appears to be 20 feet wide for, I don't know, 160, 170 feet, and that gives you 2,671 square feet of pollution generating impervious surface, which is 62% of the impervious surface for the total of 4,269. And I got those totals when I reviewed and gave public comments last November, or November of 2018. The driveway does appear to run very close to the existing house of the Hendrys at 446 to 11th Avenue Northeast. That house was built in 2007. Setbacks are needed and they should be required. 4 feet from a house is really too close for safety. The safety of the neighbors should be a paramount concern, and that's above, beside, and below this RUE lot, just not one person or one area. There are multiple critical areas, which makes this a very constrained lot. This RUE should be denied to avoid, or conditions should be added, or modify, or limit, or restrictions, or mitigation so that it does not impact safety, health, welfare of the land environment, existing trees that remain, adjacent properties, houses, or foundations. And then related to the GMA requirements, and I'm on my last page, for geologically hazardous areas, the Sammamish Municipal Code has SMC 21A.50.220 for erosion hazard. That should all apply. 21A.50.260 for landslide applies. It talks about the 50-foot minimum buffer that can be reduced to 15. But if you're doing it, whether it's a 40% slope or more, the development proposal should not decrease slope stability on contiguous properties. Mitigation on the best available engineering and geological process must be implemented that either eliminates or minimizes the risk of damage, death, or injury resulting from landslides. And finally, last but not least, there is SMC 21A.50.180 called Notice on Title. This is missing. The city is supposed to put these on, and they're supposed to do it before they approve any development. It says the owner of a property containing critical areas or buffers, or any property on which mitigation is established, shall file a notice approved with the city with records of elections of King County, so pretty much King County clerk and recorder. The recorded content should be in the form of the notice will be determined by the director, so that's from the city. The notice shall inform the public of the presence of critical areas, buffers, or mitigation sites on the property, and the application of this chapter, which is the environmentally critical code of 21A.50, to the property, and that limitations, and that the notice shall run with the land, and that the applicant has to submit proof that the notice has been filed for public record before the city can approve any development proposal. So that's my 8 pages. I tried to just summarize them. The city does not map steep slopes. There are contours, which are 2-foot contours available on the city mapping tool. While no mapping is perfect, it is a good thing to use, and I believe you can see most of what you're looking for on those maps. And it would really help if the city did do steep slope mapping, which I've been trying to ask the city to do for years. So that's my comment. I did also give comments on November 20th at the deadline for that, and I don't believe any of mine were responded to, but I keep giving input because I think the right things need to be done to protect the trees, the area, the people, and we want successful building sites, not building sites that start, get bigger, get stalled, and foreclosed. This lot is actually foreclosed twice. It sold for $93,000. The 4 lots below it have foreclosed multiple times, and we're just not seeing successful building happen in the area. So the city really needs to look strongly at these, provide the oversight, make sure the mitigations and conditions are established, and just not approve things without those being answered. Thank you.
Thank you, Ms. Wichter. For your information, your earlier comments are contained in Exhibit 7 from pages 23 through 49. So the ones you submitted last fall are, or last year or a year before.
Thank you. I think it was November of 2018.
Yeah, I think you're right. They are in the record at the page numbers that I mentioned.
Right, and I realize some of those would be suitable for a building permit and not for an RUE, but I think in order to be able to figure out if something is safe and available for an RUE, you do have to look at some things. You can't just say, oh, we'll do it later, because when you can't, that's how we end up with the stalled project.
Thank you very much.
Thank you.
Okay, now on my screen, the last 4 are folks who are previously accounted for. I have Ms. Graber. Then 27, I think if my memory's right, is Mr. Walker. 29 is Mr. Gillette, and 30 is Mr. Johnson. So I think we've run the gamut on the public testimony here. I have 156. It's been a couple hours since we had our half-hour break. I'd like to take a 10-minute stretch break. And so we will reconvene at 10 minutes after 2, at which time we will begin the rebuttal round. And I'm thinking that that will go much faster than the direct testimony did. So we'll take 10 minutes. Ms. Graber.
Mr. Galt, are we planning to do written closing, or will that be after the rebuttal round?
I'm open to whatever the principal parties want to do.
Okay, I'm going to go on the record and saying I prefer written, especially because I haven't been able to read Ms. Wichter's comments. I only heard that onslaught of important information just now verbally, and I'd love some time to digest that before I respond. So during the break process, let's give that some thought and maybe return to that when we get back.
Okay, and do remember that I have said I am going to leave the record open. To be honest with you, I'm thinking about a week for the parties to be able to respond not only to Ms. Wichter's comment, which is Exhibit 9010, but also Exhibit 1006, the comparables submitted by the appellant, and the city's Exhibit 19, which are the documents that came in today during the hearing. So anyway, we are at recess until 10 minutes after 2. Thank you much. Thank you. I'll see you after my hearing's over. Hi, Lita.
Hey, Don. I was just about to turn my camera off. It goes on.
You're at City Hall, huh?
I am, yes.
Are you across the hall in your new digs?
I am in Melanie's old office.
Yeah.
Yeah.
Looks like you haven't finished decorating it. I see a picture on the floor in the corner.
That's right. Need maintenance people available to do that.
Ah, they don't trust you folks with a hammer and a nail?
No. You need to get maintenance to come and put it up for you.
Oh,
Okay.
does anybody other than you show up at City Hall occasionally?
Just a few people, mainly people that have offices that close the door.
Ah, okay. Yeah, makes sense.
Yeah.
I suppose there's somebody down in that little police substation.
Yes.
Yeah. Well, someday this will all go back to normal.
Yeah, it's a lot more difficult doing an appeal hearing when you're not in person to get copies of.
Yeah. And I ran into a problem. I don't know what my machine's doing to me today, but some of the exhibits, when I click on them, now see that one opened fine. That was 5.
You're not able to scroll across?
Well, no, some of them, I click on it and the machine will tell me, this is a PDF file, but we've had a problem and sorry, you can't open it.
Oh.
And then it gives me a thing where I could click to download. But then when I click that, it says something like, open your Dropbox account and create a download to it. I'm thinking, that's not what I want to do. So,
Oh.
but
Maybe
it's because they're documents. The other day when I was reviewing them, I looked at all of them and I didn't have.
Okay.
So I think it must be something, either my machine or Dropbox is just grumpy today.
Maybe, yeah. Okay, I'm going to sign out.
Okay.
Take care.
You again. Yeah, I don't understand this. Is everybody here that needs to be here?
Mike Gillette.
Ms.
Terry
Beatty,
Walker.
good. Walker and Gillette stayed live through the recess. Thank you, gentlemen. Ms. Beatty, shall we go ahead and do it?
Yes,
We are recording now?
we are recording.
We are. Thank you very much. Okay. Our afternoon recess having run its course, we are continuing on and we begin the rebuttal phase of the proceeding. And that will start with the appellant. Mr. Kindry, do you have any rebuttal testimony or evidence that you wish to present?
No, I do not.
He declines. Thank you. Ms. Graber, does the city have any rebuttal testimony or evidence to present?
No, thank you.
I just finished telling my wife and granddaughter I probably had another hour and a half to go. I think I lied to them. Walker.
Just a couple things, just a couple comments. I wasn't really able to hear all of what Mary Wichter had said.
Hang on a minute. Hang on a minute. Are you going to testify? Up to now, you've just
yeah, I'll testify.
Okay. Raise your right hand.
Okay.
Do you swear or affirm that in your role today, any testimony that you offer will be the truth, the whole truth, and nothing but the truth?
I affirm that, yes, correct.
Thank you. You'll note that I tossed a couple of words in there to make a distinction between your participation as an attorney and your upcoming testimony. So if you would be
I'm not quite sure what you mean by the distinction. I'm the applicant and the attorney.
Well, I understand that, but up to now, I've been treating you as the attorney.
Oh, okay.
Lots of attorneys don't like to be sworn in no matter what the
I guess they're being sworn at.
Would you tell us your name and how to spell it, please, for the record?
Sure. First name is Jerry, spelled Jerry. Last name Walker, Walker.
Okay, thank you, Mr. Walker. As applicant, go ahead with your rebuttal.
Sure. I just had a couple comments in regard to what Miss Lovely had said. I just want to point out a couple of things. In regards to Miss Wichter, I could only hear maybe half of what she was saying, so I would agree that maybe we sort of allow for some sort of written response to that, or a 8-page letter, which I haven't seen, which I'm assuming her comments address that but I just couldn't speak to a lot of them because I just couldn't hear. In regard to Dawn Lovely, I just wanted to point out just one thing in regard to her testimony. She's the neighbor, if you recall, that is directly adjacent to this lot, did an addition onto her house, had to hire a geotech, and she actually attached a portion, excuse me, of that geotech report, and that is Exhibit 7. And if you look at Exhibit 7 on page 18, excuse me, this is a second paragraph down. It says, given the subsurface conditions present at the site, it is our opinion that the risk of damage to the proposed project by landsliding in this area is low. Development within the area of the planned addition is acceptable, provided that any clearing, grading, construction within the area is conducted in accordance with the recommendations presented in this report. So I guess my point is there's 3 geotechs that have looked at this general area. They've all concluded the same thing, that any issue with any danger from landsliding is low. So again, 3 different geotechs have reviewed. I just want to point that out. That was in her submittal, not mine. And again, Mary Wichter's comments, we'd like to address those at a later point in time. And then in regard to Mr. Kendry's comments, I mean, he had some general comments about being a danger to his family, but again, anybody that has a road or an easement or an access to their house, there is always going to be a danger there. And of course, that can be mitigated. Can put up a fence, can put up a gate. There's all sorts of ways around any potential dangers associated with an access easement, which again are fairly common to have driveways or other easements to houses. Regard to his comments about sheeting water runoff, again, that'll all be addressed at some later point in time during the building permit review process. This really, I mean, it seems like people are sort of getting I wouldn't say ahead of themselves, but to me, this process is just determine whether an exemption exists for this project, whether it's constrained, and whether it meets 4 criteria. And we're talking about, flow controls and all these other things that have to be implemented by the city and a part of the code, but really have nothing to do with this particular project. So again, I guess my rebuttal just is that just want to point out those couple things and just reiterate the fact that it does meet the 4 criteria, and the city had just has met their burden on all 4 issues. That's really all I had.
Thank you, Mr. Walker.
And if I could have one point of clarification, you earlier had mentioned in regard to calculating, trying to calculate the slope of this lot. Could you, and I didn't quite fully grasp what you were stating, could you reiterate what you were trying to calculate and what document you were looking for? I think some of it was addressed on a map.
I don't remember the exhibit number now where it was pointed out that the extent of the erosion hazard area and the CARA extent were graphically mapped on one of the exhibits that you'd submitted. And I was inquiring, is there a similar mapping of the 40% and greater slope area? And apparently there is not. And my comment was, well, yes, the topography's there. And I can, if I had a properly scaled document to work from, I am able, because of my experience and training and education, to calculate the slopes and try and find the 40% slope, top of slope line on the property. But I am most commonly used to finding that an applicant has submitted an exhibit where their surveyor or geotech or whatever has graphically depicted that so that it's right there on their exhibit and everybody can see where the top edge of the slope is.
Oh, I thought that had been done on one of the exhibits to the Riley report towards the end. I thought it to me, it graphically showed a cross section of the hillside and where the proposed development was going to be up at the top.
Well, a cross section doesn't tell you the aerial, AREAL, the aerial extent of the steep slopes. It just shows you a slope at a given section through the property, not the same.
Okay, I'm not a.
I was just surprised that there was no graphic in the record showing the extent of steep slopes on the property. That's all.
Okay, I was just curious if that's a document you want to request, and if so, where to look to get it. I guess the geotech could generate such a thing if necessary.
We'll deal with what we have.
Okay, then I don't have anything else unless anybody has any questions for me.
Okay. Is there any cross-examination desired of Mr. Walker's rebuttal testimony?
Not
Question. Sorry, so someone saying something before?
Well, I'm trying to figure. Oh, is that Mr. Kendry who was talking? Do you have any cross-examination of Mr. Walker?
I have a comment to what. I'm sorry, I'm hearing feedback and apologies. I've got landscaping in the background. Someone else trying to say something? Mike?
Well, I probably was stepping over you, and I apologize for that. I was going to say that I think Mr. Gillette's been handling all your cross-examination.
I just had a comment based on what the statements
Comment or a
made.
question?
It's a comment.
Then that's not cross-examination.
Okay.
I must admit, I'm sitting here looking at my notes and wondering, why did I start rebuttal with Mr. Walker? That was my fault. I apologize. The appellant should have gone first for rebuttal. Mr. Kendry, do you have any rebuttal that you wish to present? Now's the time for your comment.
Yeah.
If you do, go ahead.
All right. So this is based on the comments that LPI just made in terms of this being any other easement. I just want to call out that it's not typical of any other easement. There are requirements here within it that, based on the impervious surface, requires an additional 10-foot for vegetated path. And all these things are not part of any typical easement. It's dangerously close, so it's 20 feet of the driveway easement that's been called out. Just want to make that distinction. And the other part about stating that there could be a fence put in place here, I just want to call out it's a non-exclusive easement, and I have a right to my property, and therefore there's no question of a fence being put in place, which will make it any bit safer for my family to use because of the easement.
Okay, thank you, sir. Rebuttal from the city? None? Thank you, Ms. Graber. Okay, then it's time to figure out how we want to do closing statements. My original thought was to leave the record open for 1 week, which would be to 5 p.m. on September the 16th, for submittal of comments on those 3 items, documents that came in today that nobody's had a chance to look at. That if you want to do your closing after you've had a chance to see those documents, that pretty much means that you've got to agree to written closing, because I see no sense in adjourning the hearing or recessing the hearing and coming back in a week just for that. I think trying to do the scheduling would be just a little bit more than it would be worth doing. So normally, closing, if it's done orally, would have the applicant first, city second, appellant third. When we do written closing, I have had counsel who are happy to turn in their closing statements all on the same day. All 3 parties do it on the same day. That way you admittedly don't get a chance to respond to anything that the others have written because you're turning it in at the same time. The other thing that we could do is sequential and follow the normal order so that the second and third closers would have the chance, just as they would in an oral closing, to hear what the other party said first. And we could, as far as I'm concerned, I think it could be done. Maybe the parties' counsel here wouldn't agree, but I would think that the first closing statement could perhaps be submitted at the end of this week when people have had a chance to review those 3 documents. So I guess my initial proposal would be to have the applicant close on September 16. And then the city, and I personally, I don't see the need to provide a week between each of these closing statements, because I would think that you could be working on it and getting it largely done before you see what the other party has to say. So in that case, I would be saying, how about if the cities was on Monday, the 21st, and the appellant on Friday, the 25th. So
The
that would be
city,
my,
the city likes that idea.
that would be my proposal for us. Mr. Gillette? You'd be last on September 25th. You'd have 4 days after the city submitted its to finish yours. Are you there? Hello?
I'm sorry, can you hear me now?
I
Can you hear
can
me
hear
now?
you now.
I'm sorry, I had muted. I was having quite a conversation while I was on mute. And my response is that that schedule seems perfectly fine to us.
Okay, thank you. And Mr. Walker?
That's fine with one question. I mean, I guess my preference, I guess my first question is why do I have to go first?
As I say so.
Okay.
Because the rule of procedure says so.
Okay, that's fine. Then my next question is, and this maybe is more a question for Ms. Graber, is that I prefer maybe to do some sort of a joint response or join in their response, just because she's getting paid a lot more to do this than I am, because I'm getting paid nothing to do it. So I might just have a chat with her, and if it's possible, if I could maybe join in with her, if that's possible, so that way, if we do a joint response, it would still be on the 21st.
That's between you and her. I'm not going to
Okay, I just want to reserve that possibility because I don't want to duplicate efforts and.
Yeah, I am not going to get into that discussion at all.
No, I just wanted to be allowed to file something on the 21st if it's a joint response or joint closing. That's all.
If it's a joint closing, one document from two parties, that's okay, but not two documents on the same day.
Correct. No, I didn't intend to do that. I just intended one document.
Joint means joint.
Okay.
And whether you two do that or not is entirely between the two parties. As I said, it's not my call.
Okay.
Okay. So there we are. Now, Ms. Wichter, you don't need to respond to your own document. And it looks like Ms. Lovely has left us. I was going to ask if she wanted the time to submit a reply to any of the three documents. I have the feeling she wouldn't. So we'll just leave it that way. We will close the record today with the parties submitting written closing September 16th at 5, not later than 5 p.m. for the applicant. September 21st, not later than 5 p.m. for the city. September 25th, not later than 5 p.m. For the appellant. Please submit them electronically to the city. Ms. Beatty, do you want them to send them to you or send them to Ms. Hatchie?
I believe protocol is to have everything go through the city clerk's office. So if everything could be emailed to Ms. Hatchie, then we would be within rules and procedures.
Okay, that's what I expected. I just wanted to ask. So please do submit them that way. Each closing statement that is submitted will become a part of the record and will be assigned the next available exhibit number for each respective party. And again, to reiterate probably for the nth time, if the applicant and the city want to work jointly, that's their business. And I'm not saying do it or don't do it. If you do it jointly, then the submittal time would be the 21st. Okay. Is there anything that I have forgotten to tidy up before we adjourn? Doesn't look like it. That being the case, thank you all very much for a most informative and interesting hearing. And I look forward to getting your closing statements in due course. I am going to put the little button on my screen to leave. And so at this point, our hearing is adjourned, subject to the submittal of the closing statements. Thank you all very much. Take care.
Thank you.
Thank you.
Thank you.